Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, sometimes known as Rekieta Law, a small law firm in central Minnesota. And today, we have some documents to cover, and we have some topics to talk about, and we have some emphasis to drop on some words. Hey guys, how's it going? I have a confession to make right now. This is breaking. This has never been heard before. This is something new, and it definitely matters. I am lying right now about my energy level, and I am really working myself up into it because I was just passed out on a couch, asleep, as I have been just absolutely crushed on my sleep schedule lately. My sleep schedule is hot garbage. Make no mistake. And if you were in the Discord, not the Discord, that's for the $100 patrons. No, if you were in the Discord earlier today and participated in Live Chat Wednesday, you would know that I am a tired man. That I did not get much sleep last night, or I think the night before. But, it's just, I'm very busy. These are good things. It's good to be busy, right? And oddly enough, for a narcoleptic, I've been having trouble sleeping because I've been thinking about a lot of different things in relation to YouTube and stuff like that, and how to carry forward on the channel, which I'll probably talk about sometime soon. Nothing drastic. But anyway, so I lay down, and normally, as a narco, I hit the pillow and I am blissfully unconscious for anywhere from 4 to 8 hours at a minimum. And that's only if I get woken up. But lately, I hit the pillow and then my brain turns on. So I'm like a normal person, and that is terrifying. It's horrible, and I never want it ever again. I want to go back. That being said, we've got some good stuff to cover, though. We do have the transcript. We do have the transcript of the November 8th hearing for Vic's case. I have some other updates, I guess. We're waiting on some stuff. Excuse me. A motion for motion for continuance of the hearing that's scheduled for tomorrow has been on file at the courthouse with no answer. And so I'd like to update you guys on that and let you know where that stands. I'll do that in just a little bit because otherwise I'm going to get asked again. So just bear with me through the intro here, and we will do all that as we get into the topic tonight. But I'll cover that for you. We're do a little theory pitching here. We're do a little theory pitching on what's going on. I'll tell you kind of what has been bothering me about both sides of this lawsuit lately. There have been some weird things, some things that have been missed by both sides, I feel. And nothing, these are not, these are strategy things, and they're not for me to determine, or even, it doesn't mean that either side has to listen or do what I think they should do. They're just some things that I would do differently in both of their positions. And, but maybe that's why I'm on a microphone and they're in a courtroom. Maybe that's true. I don't know. I think, but there is something to observing these things where it gives us a chance to say, well, in this great, perfect universe where all I'm doing is looking at this, and I'm not making the decisions, and I'm not doing the day-to-day grind, and I'm not also managing, all of the other work of the firm, we can look and say, well, this is what we might do. So I have some ideas on some places where I think both parties have kind of missed some opportunities over this recent drama. That's what I'm talking about. We're not going to go back. We're not visiting the past, the TCPA, because there's a wild card in any TCPA. And that wild card is a judge. And some people, I do think some people forget that I talked about the human element, the wild card of the judge from the very beginning about this case. And I didn't expect a judge to chup it up as much as Chupp, but Chupp chupped up pretty chupping hard. And that's something that was, I did not see coming in the way it did. I mean, I knew it was possible, but I really didn't see it that as catastrophically as it came. Now, I know there are people out there who are like, oh, we told you the whole time. Now, I'll still maintain that I don't see anything particularly insightful or enlightening about their legal analysis. The fact that the judge went their way, not in the way that they anticipated and not for the reasons that they would suggest, and not on all of the issues in the manner that they would suggest, that I don't think there was any sort of special sauce happening there. So this is why I'm not going back to re-argue the TCPA and all that stuff. That's not what I'm talking about. I'm talking about in the new stuff, given the dismissal of all counts, and then what we've got following that. I think both sides have a little bit of missed opportunities. So we're going to talk about that in just a little bit. I do want to do something first. I told a friend I would do something a while back, and I didn't do it because on the day I was going to do it, I didn't do a stream. And then my other streams, it didn't fit. And it doesn't super fit here, but I need to do it. Many of you know about this. This is a GoFundMe that I've talked about before. So this show is not sponsored by anybody today. There's no sponsor for the show today. Instead, I'm doing a reverse sponsor of my friend's GoFundMe. How's that? That's a thing that I made up just now. A reverse sponsor of my friend's GoFundMe. And that is this just the only reason I'm bringing this up is because he's gonna probably shut it down very soon. And this is a cause that I personally donated to and I believe in very much. But I just wanted everybody to have one final opportunity and to know that a lot of progress was really made on this, and to just share that real quick. So if you'll hang with me for just a second, we'll oh my goodness, I gotta pull it up here. I mean, I gotta get my window. I've got it pulled up. So here we go. Here, that one. So this is Mr. W's classroom library. This is my friend Heath. He is an English language, an English teacher, teacher of English literature, English as an art, not as a language, I should say, in a high school. And what he wanted to do was he found out that the school library did not provide as robust of a reading experience for the kids in his classroom that he would like to see, and that he had backed up with various data on how many books, like what the proper saturation level of available books is. So he asked for a bunch of money to buy a bunch of books. Many of you donated, I donated, and then actually some people reached out and got some publishers to specifically donate books, which was also awesome. And thank you all so much for doing that. Like I said, it's coming to about the time where the campaign should probably just peacefully sunset from, now. He did raise $2,810 so far. He set a very overly ambitious goal, but that was the point. Be audacious, make a big goal of $10,000, which would fund the entire library. And he didn't need to get to that to make an impact in these kids' lives. So I just wanted to post. He did a couple updates. The most recent one is here, and that's the one I'm going to focus on. So here is the library. He's got finally the new shelf is set up. Books are organized by genre and author. My reading corner is almost complete. Going to bring in a couple more lounge chairs as well. Kids have been checking out books like crazy. Thanks for everything. You can see here he's got quite a few books. And these are all books that he has had to personally purchase, right? Or have purchased through donations. He was buying books before he did the GoFundMe, and he used the money from the GoFundMe to buy books and fill the shelves. He's had a great response. The kids love it, and they're checking out books and leaving recommendations for other books and stuff like that. And this is something that will impact kids' lives, you know, for years and years to come. This stays with his classroom. Even if he moves schools, he will take this collection of books with him to the next school as part of his classroom. So this is something that'll impact kids' lives for a very long time. Really, I mean, I guess as long as he's a teacher. So I wanted to really thank you guys for chipping into that and to offer one last sort of opportunity to do so. He's going to shut the campaign down soon. But he is at that $2,810. So I think it'd be wonderful if we could kick him over 3,000, just as the last thank you. And if it does not make it over 3,000, I will personally be contributing the remainder. I will make one more donation before the thing's done. But if it doesn't kick over 3,000, I will personally do it. But I wanted to reach out to you guys as having been so generous in the past. I know many of you do really believe in educating kids and putting good literature in their hands, stuff that they want to read, right? Not just whatever boring books like some faraway school board has decided to put in their curriculum, but you know, books that you and I would have wanted to read as a kid. So there you go. Here's your opportunity to do that. And thank you so much for taking a couple minutes out of the day to listen to me ramble about something that I do think is really cool. The link is in the description if you wanted to check it out. But yeah, thank you so much again. And that's all I have to say about it. And he is very thankful as well. I mean, we really, like, I can't adequately express how much the donations that came in kind of blew his mind and really was a big shock to him. So he was very, very appreciative of that. All right. So there you go. There is that. Of course, we will also check out a certain other GoFundMe. Which maybe you guys have heard of it. This guy named Vic. Vic has some GoFundMe or something. We're gonna be talking about that as we go on today. All right, we're at a pretty good threshold here. So what I'm gonna do is I'm gonna talk about hearing tomorrow. There is a hearing scheduled tomorrow on the attorney's fees issue. As you probably know, if you've been watching, there's a motion to continue the hearing, push it back, requesting 14 days. That was filed the other day. The judge has not ruled on that motion. You know, he just decided not to rule on it. Sometimes that's what you get. So I would assume that they will go in and, you know, request the continuance at the beginning of the hearing tomorrow. However, they do not have a ruling on it. So they will also have to be prepared to conduct the hearing tomorrow. That's just what they're going to have to do. Either way, that's, you know, they've known, I would assume they would know that this is a possibility. I hear there's some prep work that has been done on Vic's team to make sure they're ready for a full hearing tomorrow. But here's the reality. The continuance is easier on the judge because there are, you know, hundreds of lines of billable hours from 3 different people. And if the judge doesn't grant a continuance for them to properly address all of that, then they have to properly address all of that at the hearing, which means you bring in expert witnesses to testify about what is what even is a proper billable hour, what is a proper rate, what is the going rate, what is justifiable, what isn't, what should be included in a TCPA, what shouldn't, all of that stuff. You bring in someone to do that. You've got your expert, and you may be calling up the billing attorneys as witnesses to justify their billable hours, to ask them, to cross-examine them about these billable hours, to ask why there are duplicated entries, to ask how something could take so long, to ask what generally does it mean to pursue strategy, for example. Like, what is 5 hours of pursuing strategy looks like? Like, what does that look like? We know it's no FAP November, and a FAP November might be a heart attack November for at least one of the lawyers. So what does pursuing strategy mean? What's it look like? What about these redactions here? Now, I know that there's an ambitious Kiwi out there who went ahead and unredacted a portion of the bill that seems to have maybe not been redacted properly. However, that's not that is very useful, and it's great, and it's informative for us, but it's really difficult, and it's one of the reasons why I haven't shown it on the stream. Okay, and maybe we will, probably not tonight, just because we're gonna have a packed night. But the reason I haven't shown it on the stream is because, and I don't believe that this happened, but I don't know that isn't like photoshopped, right? Like, I can't tell because it was redacted in the original copy, and we're taking someone's word that they unredacted it due to the other party's screw up. Now, I have every reason to believe that Lemoyne screwed up redacting the document, and that the Kiwi who did it was fully able to do that. And I actually have full faith that that's what's on the document. I do. But I couldn't take that into court and prove it. In fact, I would have to have an expert testify that they had to edit the document, which would necessarily cast a dubious light on it, right? So I wanted to what are you guys? You guys are spamming me some stuff here. So I wanted to. You guys are saying 3,200 for the library. Mine has not updated like that. Let me pull up a different browser. Sometimes the browsers just cache in on certain thing. Holy cats! You guys are amazing. Absolutely amazing. Let me show you. Look at this. We're up to 3,201. You guys are awesome. Thank you so much. Thank you so much. That is really just fantastic. Keith will be ecstatic. The kids are going to love it. And it's a great way to close out the campaign. So thank you so much. I'll check it again throughout the show. Thank you to Keith. Well, here, let's do this. Thank you to Keith Westcott, Dominic Lusso, Rogel Dorn, The Last Wall. Thank you. Nathan Smith, Julie Drohan, James Taylor, famous singer. Thank you so much. And Anonymous. You guys have made a fantastic impact. Thank you. Really, it's very personal to me. And thank you so much. And Brian Dewig as well. You guys are great. I'm getting up. I'm not having an emotion. What are those? Wait a minute. Someone has an outstanding super chat offering $500 if you match it. Bob the Troll King. You put $500 towards kids' books and I will match it on air. Absolutely. 100%. Let's do it. If anyone wants to join us. You just tag me and let me know when you've done it, and I will put up with you. Absolutely. I don't I said I will show people's GoFundMes and stuff, but if I'm gonna really promote something, it's something I'm 100% comfortable donating along with it. So yeah, thank you. Absolutely, that's huge of you, man. Okay. So back to where we were. As far as the redacted documents that are unredacted, the reason I haven't shown them on stream is just because that's not something. It's very informative for Vic's team, absolutely, but it's not something they could take into court and say, see. I mean, they can try, they can use it, but they can't prove it necessarily. So they would have to use it to request, production of the unredacted versions. There's some issues with providing a redacted copy. They should have provided what's called a privilege list to the court. You can't just redact stuff. That's this neat thing. You can't just redact a bunch of stuff that you're asking for. You have to do it in a proper way, especially because those redactions, you have to be asserting privilege. They didn't appear to assert any privilege over it. They just expected to redact it. You'd have to provide a privilege list to the judge, which would indicate what material was actually redacted. And then the judge would have to make a determination based on the information provided to him as to whether or not that could be properly redacted. So, but yes, and of course, only part of the bill was able to be unredacted. So it's a mess. It's a mess. But they're gonna have to go line by line and argue about all of these things. And the hearing is set for a whopping 2 hours. That is not enough time. That just flatly is not enough time. There's no way in 2 hours they're going to get through like 50 pages of bills. Going through and challenging these things out. Another aspect of it is, of course, Vic's team necessarily must take the position of, many of these fees do not apply. I'm assuming they'll take a very, very narrow position to what fees, if any, apply. There may be an argument that none of the fees apply due to the bad actions of the party, of the defendants. And, I think, well, let's just say it. That bill, the unredacted version, if it's true, if we're to take it as true, which I do, Ron and Monica perjured themselves at deposition in regards to billing. And this is directly relevant to billing. And the bills show that. The billing shows perjury. Ron Toye and Monica Rial lied under oath at deposition. There's no bones about it. There's nothing else you can say. Monica Rial and Ron Toye both said they did not prepare for deposition, that they did not prepare and have a chance to examine documents at deposition or prior to the deposition. Yet on the bill is a significant charge, several hours of a meeting with clients to prepare for deposition. So they've perjured themselves. And specifically with a document review. So that's one thing. Another thing is both Monica and Ron were asked who is paying, is anyone in any way directly or indirectly paying your legal fees? They said no. Well, a curious aspect of that is on one of Casey Eric's bills. It specifically lists as the client Funimation, not Monica and Ron. This is perhaps explainable, but, what's that explanation going to be? No, it isn't. It's just, I just wrote for my clients in my billing software. I just accidentally wrote the name of a different defendant. Huh? Wait, what? What is this? that's a problem. And you know, they'll have to shore that up. Maybe they could produce a check blank from Monica and Ron showing they paid. Maybe. I mean, who knows how they'll end up doing it. But yeah, so I don't know what they're going to go after on that. I do not know how far they will take that argument. If it were me, I would push for blanking them on the fees for lying under oath. And especially when it's about this, that they lied under oath. I mean, well, you know, and they obscured it. And the attorney, one of the attorneys asking, actually, that redaction of the deposition prep with client, I mean, that show, why would you redact that? Why would you redact the preparation for deposition from your billing? That don't make no sense. Why would you do that? If you are asking for your fees for the thing that you if you're asking for your fees on this, why would you redact something that should, in theory, be related to the TCPA? Because they're going to claim that those depositions are related to the TCPA. They already are. So, wait, Bob did it, huh? Did he? I'm not seeing it just yet. I'm not saying it didn't happen. It's just my, another browser. Let's see. Clear cookies. Reticulating splines. Hold on. What do we got here? What do we got here? Ho, 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 baby! Bob! There it is. There it is. I am, I see it. I'm gonna get my... I need my credit card. Do I? Do I need my credit card? Maybe it's stored. I don't think it's stored. Let me check. Let's see. Okay. Let me just get this going here. Oh, dang it. Yeah, give me a second. I gotta go grab my card. I'll be right back. Okay. Sorry about that. I am, let me just show my credit card on screen to prove that it's... I'm just kidding. All right, here we go. Now, I'm sure someone on Kiwi Farms just figured out what that number was by hearing the clicks of my keyboard. Oh my goodness, here we go. Confirm. Did we do it? We did it. We did it. Let's see. Return to campaign. Here we go. I have matched you. I have matched you. There it is. We're up to 4620, y'all. Thank you so much. You guys are awesome. You guys are awesome. Oh, goodness. Let's see. Bob the Troll King, man. Good challenge. Good challenge. I appreciate it. And more importantly, of course, great for the kids. Very awesome. Very awesome. Show Ridge Wallet. Here's the Ridge Wallet. Right there. There's the Ridge Wallet. Very cool. I'm loving the carbon steel or whatever design. It's great. But I'm not doing a Ridge commercial today. Not doing a Ridge commercial today. Yeah, I'll give Bob a wrench for sure for the challenge and the donation, but I can't until it's hard for me to do it. I need him to chat something. Bob, say anything. Not a super chat, just say anything. There you are. Okay. Don't mod me. Oh, you got modded, bro. You're done. Okay, and let's read through these donations here. We've got because we got a whole bunch of them. We've got Stefan Desjardins. I don't know how the pronunciation goes. I hope I didn't kill it too bad. Daniel Handeland, Godiva Mahoney, Anonymous, Martin Lund, Fancy Gusto, Anonymous, Tom Young, Davey Johnson, Bob King, Jacob Buchanan, Emma Kazmierski, James Ketter, Felipe M, and Nick Rekieta. Hey, thank you all so much. You guys are great. Absolutely great. Okay. Let's finish introing these documents, and we will return to that library fund later in the show just to take a peek on where it's going. Let me pull up the here we go. Let's where's my document? Where's my document? Here we go. All right. And did you guys see my boomer thumbnail from earlier? I had this idea earlier. I can give you the lore on this if you want. Here we go. Yeah, there we are. Look at that. How do you do, fellow kids? This is inspired. This is inspired because by if you haven't seen Lemoyne's Twitter, first of all, it's an absolute disaster. And he loves Nickelback. And he also uses bro a lot. A disturbing amount. Lemoyne says bro more than Vic says bro. And that's a lot. That's a lot of broage. Okay? He is broing constantly and trying to identify with the Utes and the non-diseased persons. So with that, I just, it feels like he's trying to fit in, right? Something that's hard for him to do because he can't sit quietly. It's the Utes. So that was if you missed the boomer thumbnail, that's the one I put together. My artist, of course, put together a more professional thumbnail, and ultimately those have to be the ones to stay on, because guys, do you know that YouTube's distribution algorithm does 70% of its decision making on whether or not it will distribute and share your video based on the thumbnail. 70% of the equation. So there you go. Machine learning, man. Looking at pictures. Looking at pictures. But yeah, so here we have the transcript. Now, there is this is a fully clean copy of the transcript. And there's a Kiwi who went and I think Alanon, shout out to Alanon, who went through the horror of removing the sped not watermark and updating the hashtags to be something less than the anal cancer that is Greg Doucette's sense of humor. So I will give a lot of props to Alanon for doing that, and as a show of the props for that, we're going to go through Alanon's hashtags after we go through the document. Because I don't want his hard work to go in vain, and his hashtags are certainly better than T. Greg's lame attempts at being a person, rather than a deadbeat. I was thinking the other day, T. Greg had said something about no one has ever seen my kids, right? That's not true. First of all, lots of people have seen my kids because I live with people and we interact in the community. So there's that. Other than that, my daughter has been, people have hastily pointed out when her reflection is visible in the Mortal Kombat cabinet. But I was thinking about it and I was like, why does T. Greg think that no one's ever seen my kids? And I was like, oh, that's right. Because he doesn't see his kid. That's right. That's the abandoning thing. So I had to process, like, where's this projection coming from? And that's what it was. And it made me a little bit sad. But it also made me happy because maybe the kid's got a chance. Oh, you know what's great? You can't say that that a deadbeat dad who doesn't pay his child support doesn't give his kid anything. He gives him poverty. And also a higher chance of becoming a criminal. It's perfect. It's absolutely wonderful. Great gifts to give your child, statistically setting him up for failure from the start so he could follow in dad's footsteps was the ultimate gift. So, yeah. All right. We do have some chats that have come in. I've put off talking about them just because of the GoFundMe and all that stuff. Let's do the chats. Let's get the document. Let's hit it hard. The Roger X3 says, please don't be late and gay. Please don't be late and gay. I think I might have been a minute late. I'm sorry. It's only because I was asleep. Brian Duick says, have you seen the FTC comments about YouTube creators being a fish in a barrel to fine over COPA violations yet? I have not seen the FTC comments about it. Although I hear that another attorney by the name of Ian Corzine is interested in talking about it. So I'm going to try and set up a thing with Ian Corzine to talk about his impressions of it. I've got a guy who is not an attorney, but is a cybersecurity and data professional and I think that he might be great to bring on to as an expert outside of the legal field, but someone who definitely has to deal with COPA as part of his day-to-day job. And so I want to bring him on. I think you'll like him too. He's hilarious. Really good guy. So I do want to have discussions on it. For those of you who are asking, I do plan to cover the topic. I am not adequately read up on COPA or the recent rumblings of the FTC, and I don't trust the random spurging about what YouTube is definitely going to do as far as COPA goes. I want to bring on some educated opinions and get their takes and ask my questions along with you guys. So stay tuned for those announcements of those shows. I want to bring on really good and informative guests for you guys. Also, I've been meaning to shout out Kendra Paris, who's on the show. Parrish? She was the red flag lawyer down in Florida. She apparently has a YouTube channel. She has a YouTube channel now. So I'm going to try and get her back on so she can promote her channel and talk about more gun stuff with me, because gun shows are fun. And it's a better gun show than my non-gym flimsy arms can produce at the moment. Ike 13D says, hey, Nikki, have a shot of Knob Creek on me. I don't have any Knob Creek, but we'll have a shot of something. I'm pouring one out in memory of my grandfather. He taught me to shave, shoot, and sharpen my knives. Passed away recently, but he's in a better place now. God bless you, pal. Hey, buddy, I'm with you. I don't have Knob Creek, but I have Corner Creek, which is a great little bourbon here. Oh yeah, and I hope you guys liked Camelot. If you missed the Camelot show from last night, go check it out. That guy's full of interesting stories. GameStop is an absolute disaster, and he's shining a light on it, and it was good. Here's to you, Ike 13D, and to your grandfather. All right. Blackberry Jim says, how much Chupp could a judge Chupp if a judge Chupp could Chupp this whole freaking hearing? It's a good question. Bob the Troll King, we covered this, but Raggets, if I put 500 toward the kids' books, would you match me? I did. I matched you, bro. Escher Shill says, whiskey money. Thank you, Escher Shill. Ethan Amante says, hi, Nick. What's your recommendation to fight back against COPPA? I don't know. Don't have one. I'm not going to pretend to have one. I'm not going to give you a hot take on COPPA or COPPA itself. What I am going to do is try and get as much information in front of me and you as possible, and we can talk about it as a community. Bob the Troll King says, damn it, chat, you beat me to it. I was going to be smug about it. Anyway, these kids deserve a better chance than our generation had. Amen, brother. Amen, brother. Next, we've got Jay Sean Lemoyne. Greetings, Rekieta fans. Politics make you sour? I'd just like to announce you all that I'll be running in the 2020 presidential elections. To learn more about me, my independent party, our platform and policies, please visit lemonparty.org. Thanks. Lemonparty.org. That's it's up to y'all. If you want to check out his campaign page, you do that. You do that. Freighter J says, Lemoyne, Mary, sir, they have committed false report. Moreover, they have spoken untruths. Secondarily, they are slanders. Sixth and lastly, they have belied a lady. Thirdly, they have verified unjust things. And to conclude, they are lying knaves. So there you go. Felipe Mube says, so Nick, your friend's library has Playboy, the complete centerfolds, because that was the book I wanted to read when I was a kid. Yes, but it's the expurgated version that is text only. So unfortunately, it's really a thin volume. Oh my goodness. All right. I said we're going to do this document. We're going to do this document. And in honor of being irritating, I will be doing Lemoyne's voice for all of Lemoyne's parts. Because at the end of the day, this is a case about voice actors. And they're voice acting. And so we have to voice act with them when appropriate to ridicule and mock a severely overinflated ego. And a very terrible human being. Don't worry about my voice. I've got whiskey to lubricate. We're fine. And Mr. John Volney will be played by the voice of someone with one of those boxes, and that's only because he was on a speakerphone. And the courtroom speakerphones have the same quality as the speakerphones of 1987. So that's not a John Volney thing. This is making fun of the court thing. Never want to be on there. It's also great when Judge Chupp completely forgets that Volney was on the phone. That's funny too. Oh, and Sam Johnson, who I think maybe fell asleep or died on the phone call. We're not sure. No, and I'm not going to give Martinez an appropriate Spanish accent. I don't know how to do an appropriate Spanish accent. They're always inappropriate. So the court, may I remind you, the court is Judge Chupp. All right, who's on the phone? Your Honor, yes, John Volney for Funimation, along with Christian Orozco and Scott Smoot, who's our paralegal, who has to listen in today. Okay. And also, Your Honor, this is Sam Johnson for defendant Jamie Markey. Yes. That's accurate. The court says, okay, well, everybody is here, I think. And who wants to do the deposition? Mr. Martin says, good afternoon, Your Honor. Brant Martin with Wick, Phillips, Gould, and Martin. Just as a housekeeping matter, Mr. Lemoyne was going to argue the motion to quash and the motion to compel. It was he that noticed up the deposition. I'm here because they filed a motion for sanctions against one of my lawyers. He's a partner, though, but it's one of my lawyers. And so I was going to conduct that piece of it if it's, you know, with the court's permission. We would like to split it up that way. That's fine. Okay, so I'll let Mr. Lemoyne answer the questions about the deposition. Arctic Pride says, you have this Hispanic's permission to be as offensive as you possibly can. I can't do Martinez dirty like that. I can't. It's the slow-mo Rodriguez Martinez. Okay, so you want to depose Tosh. Tosh, yes, sir. What? Yeah. Oh, God. And I will pause to add some commentary to what's going on because I think Lemoyne gets a little bit beat up here. And again, I'm going to reference back to Lemoyne's Twitter, knowing that not everybody has seen it because he's such a coward that he went into full protected mode and called everybody incels. Oh, like a 400-pound woman. But if you haven't seen it, Lemoyne waxed philosophical about how great of a trial lawyer he is and how being a trial lawyer has kept him sharp and fixed his brain after West Nile. And no, I'm not kidding. While I don't think Lemoyne is a particularly terrible trial lawyer, nothing in this hearing indicates, or in the TCPA hearing, indicates that he is at all a good trial lawyer. He's like just a guy who shows up in court. And the harsh reality for him is that he's so insufferably unlistenable that it might not even be his fault. But at the TCPA hearing, Chupp didn't want to hear any of it. Didn't want to see his stupid slideshow. He didn't want to hear his presentation. He just wanted him to get on with the argument and do it. Whereas Lemoyne had prepared like this orator's endeavor to talk about the evils of Vic Mignogna's woman-hating prosecution. Whatever he came up with. Here, you'll start to see some things with that as well. He thinks he's got really strong arguments, and they're just falling dead, deader than his lung. And you sent him a deposition notice out in the Odessa Midland area. He is not represented by counsel, I assume. He has counsel. I think his name is Brian McKay. I've been in touch with him. I want to touch him. But he is waiting to see what this court does. Okay, but he hasn't filed a motion to quash. Y'all have, right? That is correct, Your Honor. That's Martinez. Martinez, I hope one day to meet you, and I apologize for everything that's about to happen on this live stream. Sorry. They did bring up the fact that you did not ask for leave of court to conduct discovery, I think. And you'll notice another thing. Chupp, in this hearing, does not seem to understand where he is at any given time. He's constantly underinformed, or at least that's the role he plays. And maybe that is a role. Maybe that's him saying that that's how he does things. Maybe he wants to really challenge the lawyers. To be better or something. I don't know. Or to inform him. But one could interpret it as he literally isn't reading the documents that are coming before him. That's just one interpretation. But maybe. I think. That's correct, Judge. So do you think you need to? Wait. Oh, ask for leave to conduct the discovery. No, Your Honor. What rule do you get to follow? This is the bad sign, right? Like, not why. What rule do you get to follow? Which one? What rule? What rule are you following here? So I'm following this court's order and TCPA 27.003C, which says if you have, I don't know if you have our reply brief. Even Lemoyne doesn't think Chupp's reading this stuff. Yes, I have it. If you look at the second page, it puts your order side by side with the rule on, or with the statute. The statute doesn't say final judgment. The statute says ruling until the court has ruled on the motion to dismiss. You entered an order that said you have ruled on the motion to dismiss. That means suspension goes away. Now, typically what you would have in a normal case is if you have denied the motion, there would be an appeal, and that would freeze all of the discovery. But if you have bifurcated and you granted some, and if you dismissed some and kept some, obviously the suspension would go away. So the plain language of the rule doesn't say final judgment. So Lemoyne here is distinguishing between what what he's trying to say, that his ruling is final as far as the motion, but not final as far as the fees, but it's final enough to end the discovery stay, but it's not final enough to allow an appeal. He's really stuck in a confusing place. And this isn't Lemoyne's fault here. This is the TCPA. This law is trash. As written, it's trash. As implemented, it's worse. It's a bad law. The more I see of it, the more I'm convinced. We have a judge who doesn't know whether or not he's issued a final ruling, as will become apparent. He doesn't actually seem to know. But let's go on through that. You don't think the attorney's fees and sanctions are part of the ruling, so I'm done ruling. And also, Lemoyne will tip his hand here in just a minute as to how slimy this guy is. And we called this, by the way, we called Lemoyne's sliminess, and it comes through in this document. I want to make sure that Mark Whipple knows that, yeah, we discussed this. Mark, also, God, man, get some charisma so people will just watch you. That'd be better. Mr. Lemoyne, no, you have ruled on the motion to dismiss. But I haven't ruled on the entire motion to dismiss because the sanctions are part of it, right? This is the Kafka trap or whatever. Well, the sanctions under the code is 29. It's section 29. That's correct. So I haven't completely ruled on the motion to dismiss because it's not final. I agree with that, Judge. So I don't think that you get to just start doing... Can they start doing a bunch of discovery now too? Well, they could, but what would they serve discovery for? Well, actually, if they could, your fees, and all of the fees that you're claiming, they could serve a lot of discovery for that. But you know, but I think they're taking the position that you can't do discovery at this stage. What would they serve discovery for? Their claims are all dismissed. The court, I think you probably need to have the complete ruling before. And Judge, obviously, I do not believe that based on my research of the case law, but Do you have a case that actually says during the pendency of the sanctions hearing that you can serve discovery? No, the court. Hold on. You said you did a review of the case law. That's right. Okay, but you didn't find anything in your review. Anything. This is how bad. They don't know. They don't know how they're supposed to prove up these fees. This hearing is actually not a guaranteed thing. The motions for attorney's fees and all of that, how all of this is played out is being made up as they go. This is a bad law. I can't stress it enough. The law is poorly drafted. It's not implemented. It's such a unique feature that people don't know. Like, is this a summary judgment hearing? Is it not a summary judgment hearing? Is it an evidentiary hearing? What's the process for this? We foreclose discovery, but then we reopen it, but the court still has jurisdiction, but then we don't reopen. They don't know. Even the judge who's supposed to be presiding over this, and is a common theme in this hearing, doesn't know what he's doing. In my theory, and I think I'm right, is that I know I'm right that Chupp has never had a TCPA appealed at all. He's never had a TCPA appeal, and there's one of two reasons for that. What seems like the least likely reason is that he's never heard a TCPA case through the TCPA ruling, through a final ruling on TCPA. Because if you get TCPA down, you're probably going to appeal. Because otherwise you're paying fees and all this stuff. If you don't get TCPA down, if your claims survive, the other side is basically guaranteed to appeal because there's no downside for them to appeal. They want to appeal because if they appeal and win, they win the case, right? That's the reality. If you win the case as the defendant. So they're definitely going to take the appeal, and they get the interlocutory appeal as a defendant. Oh, there's a third possibility. So the second possibility is that, and there's some indications that this might be true, Chupp has heard a TCPA case or two here and there, and he's always convinced the parties to settle at mediation prior to issuing the final ruling. That's a possibility. That's a possibility. And it would kind of explain why he thought that the mediation would work, even though he really only gave one side any motivation to mediate, that's just not even a realistic expectation that two parties will come to the table when you've just given one side everything they asked for. And by statute, they're entitled to everything else that they want. Why would you mediate? So, wait a minute. Flash hit 100K subs. Hey, congrats, Flash. Awesome job, buddy. Don't stick a knife through your silver play button or whatever when you get it. Or maybe you should. I don't know. But congrats to Yellow Flash. The third option, here's the third option, and I just thought of this as a possibility. It's possible that Chupp has ruled on a TCPA motion that has not been appealed yet, other than this one. That's a very, very unlikely. It's still within the appeal window. But there are no pending appeals cases or historical appeals cases of a TCPA with Chupp's name on them. There just aren't. That he was the judge on at the lower court. There are some TCPA cases, or there are some cases where both the TCPA is mentioned and Judge Chupp is mentioned, but they're like citing to a decision by Chupp. He is not the presiding judge. So those are the three kind of possibilities. No TCPAs ever. He's had TCPAs, but they have been settled out at mediation rather than going to an appeal. Or he has ruled on a TCPA somewhere and it's in the window for appeals. But we're talking like, you got like 30 days, 20 or 30 days to do it. So it would be like a contemporaneous action here. But my point in this is I don't think Chupp knows how to do a TCPA. I think that's pretty clear from how he's conducting it. But even here, he doesn't know. He doesn't seem to know what he's doing. So that's great. But you didn't find anything in your review. So Lemoyne has no authority for an evidentiary hearing on sanctions and attorney's fees. There's only one case and it didn't reach the issue. So there is no authority for what Lemoyne's trying to do. So Chupp is really he's really out of the water here. He doesn't have a higher court telling him what to do. Okay. And Judge, but to backstop it, to make sure we don't waste our time, we ask as alternative relief permission to take the discovery. Okay, and I'll take that into consideration then, because I can do it on my own if I want to. It says here, like reading off the TCPA statute, on the court's own motion, so I can do it anyway. So, okay, so why do you need this guy? So why? Give me cause. This is what Chupp's asking. Give me cause to give you permission to conduct discovery on Chris Tosh. Blackberry Jim says, I don't want to be buried in a Chupp cemetery. I don't want to hear this case again. Flash, a shot on you. Last time I took shots with you, man, or on you, I ended up very inebriated, but we'll try it. That's good whiskey. I wasn't on Flash. The shots were on Flash. It was a long night. It looked like a Cancun spring break. And I was just glad he waxed his navel first. That's all I'm going to say on the issue. Okay? Mr. Tosh is one of 3 people that submitted affidavits on behalf of the plaintiff. There's conflict between what he said in his affidavit and what my client said. We also think... Your client's a liar. Sorry. We also think he was pressured into signing this affidavit. And it's what is absent from his affidavit that I think is most important for the court's determination for sanctions. They think this based literally on their own fantasies. They have no evidence that Tosh was pressured to sign this affidavit. Not a shred of it. Not even anything remotely hinting towards it. Arctic Pride, that was before the homeless man argument. It might have been what led to the homeless man argument. Oh, Felipe Move says, Nick, how dare you? As a Latino, I'm deeply offended by your Martinez voice, but I understand it's for educational purposes, so you have my blessing. Oh, good. Perfect. Thank you. Mr. Clark says, great show, Nick. Just wanted to shill my Indiegogo. If anyone is interested in a dark fantasy novel, then please check out my YouTube channel. My wife recorded the prologue. If the funding goal is met, I'll eat a Reaper on the stream. Let me put Mr. Clark's YouTube channel in the chat. Oh my good God, man. Blessings and peace be upon you. Hey. Can we do it? That's not what I wanted to do. Hold on. Let me get... I have to do this in a stupid way. Here we go. Streamlabs, man. Streamlabs. Okay. Copy. Here is that YouTube channel. You can check it out. If my mods could share that a couple times for me, that'd be great. That'd be great. Go make this guy eat a Reaper. Buddy, drink a bunch of milk before the Reaper. Don't drink milk right after you eat it. Like, man up and deal with the hotness. Drink milk before the Reaper. Drink milk 40 minutes after you eat it. You know, once the heat has died down, and it's reasonable and manly to drink milk, do it. Trust me, just do it. Your stomach, your intestines will thank me for it. Also, your urethra. That's what they don't tell you. They tell you about the anus. That's not the problem. It's not, or maybe my anus might just have a spice tolerance that is superior to most people's, and that is, I think, is true. My urethra does not. And urinating out capsaicin or whatever was one of the worst experiences I've had. Yeah. Sorry, I'm remembering. Okay. So they have no evidence that Tosh was pressured or forced or coerced into signing this document. That's just their weird fantasy that they've been running with, that that somehow things are below board. Projection. Mr. Tosh's affidavit says his company breached the contract with Mr. Mignogna, and that was the entirety of their argument to try and get around the TCPA. The reason why we didn't ask the court to continue the hearing to go take Mr. Tosh's deposition at the time was just, and it doesn't get them there for the purpose of the Court of Appeals. Oh, but I think it might, Lemoyne. I think it really might get them there for the purpose of the Court of Appeals. If the Court of Appeals admits Tosh's affidavit, you're toast. And you know it. You know that the Court of Appeals, looking at that affidavit and considering it, has to go, oh yeah, of course, this checks everything in Vanderlinden versus Kahn, and we've got to send this back to jury. Like, we've got to send at least a TI has to go back. It just has to. But the fact that he did not say that Ms. Rial and Mr. Toye said something to me, did something to me, I breached the contract. He literally says it. It's literally in there as they called me, they threatened to have people cancel on the show. I breached the contract. They had people cancel. It's literally exactly what he says. This isn't in there, is in there. He's either a liar or he's hopelessly stupid. Maybe both. It is. Oh my God. Hold on. Do we have it? Do I have it here? I've got it somewhere. Let me pull it up real quick. This isn't what I want, is it? No, not this. Hold on. I've got this bad boy. Just give me a second. Where are we? Okay, I'm going to pull up the second amended petition, which has the unsworn declarations, but they are substantially identical to the affidavit. It's just the first thing. I can easily find it. Let's just go ahead and go to. Also, you don't get to do this. I have to remind people of this because I think it gets lost. It clearly got lost on Chupp. But you don't actually get to controvert the plaintiff's evidence in a prima facie setting. You don't get to say, well, we think the plaintiff's framing of the events is wrong. No, all of the deference goes to the plaintiff. That's what prima facie means. Let's take a quick look at the declaration of Tosh and see how truthful Lemoyne is being. Hint, not. My name is Tosh. I live in Ector County. Kamehakan. They were scheduled to appear. I had several conversations with Ronald Toye and Rial by telephone, and numerous text message conversations with Toye. Exhibit B is a true and accurate copy of the text messages exchanged between us. In these conversations, Toye repeatedly asserted that Vic was a sexual predator and that criminal charges would soon be filed against Vic. Toye urged me repeatedly to terminate Vic's appearance. I told him this would breach the contract with Vic. He urged me to do it anyway, emphasizing that criminal charges would be filed before April 12th to 14th. In these conversations, Toye also encouraged me not to do business with Vic in the future. I participated in a conversation with Rial in which she repeatedly asserted that Vic was a sexual predator and that criminal charges would soon be filed against him. She also implied, and I inferred, that she would convince numerous other voice actors to cancel their appearances at KamehamehaCon. I heard Toya in the background talking to her, and she periodically responded in agreement with him. Termination of multiple appearances at the last minute would have severely threatened the profitability of KamehamehaCon. Her threat turned out to be credible, since a number of the voice actors she claimed to have influence over ultimately did cancel their appearances. Rial and Toya were aware that a contract had been executed between Silverfire and Vic because I informed them both of the fact, and they repeatedly urged me to have Silverfire breach the contract. Toya also clearly implied that his company would withdraw a promised sponsorship if Silverfire did not breach its contract with Vic. The sponsorship ultimately did not materialize. Silverfire did breach its contract with Vic by canceling his appearance. After being threatened with litigation from Vic's counsel and after long negotiations and legal expenses, they agreed that Vic could attend KamehamehaCon under numerous restrictions that were not part of the original agreement, were not imposed on other guests, including Vic paying for additional security, not participating in panel discussions, signing a different location. As a result of this compromise, a number of the voice actors Rial mentioned canceled their appearances. In summary, Rial and Toya individually and jointly told me that Vic was a sexual predator who would be criminally charged before KamehamehaCon, and they urged me to breach the contract with Vic. They threatened to lead a boycott of KamehamehaCon. They threatened to withdraw significant sponsorship money that they had promised unless Silverfire breaches contract with Vic. Finally, they urged me to never do business with Vic in the future. Is there any way to read that other than they asked me to terminate the contract, they told me this stuff would happen, and I did terminate the contract? That's what it actually says. What does Lemoyne say? He did not say, Mr. Rial, Miss Rial, and Mr. Toya said something to me, did something to me, I breached the contract. He literally did say that. He literally says, they said something to me, they did something to me, I breached the contract. It's exactly the opposite of what he said to the court. It's the exact opposite. The man is detached from reality as he is oxygen. And those two are correlated, I guarantee you. Lies directly to the court. I gotta say, even though his penis doesn't work, the man's got balls. Oh. We think that is because he told the plaintiff that he didn't terminate the contract based on something that they did or said. Oh, man. I hope they get to the bottom of this at court. Wouldn't that be great? Wouldn't that be great if Tosh had specifically told the plaintiff what had happened? Like if, I mean, hypothetically in all of this kerfuffle, right? That the plaintiff said, look, man, or that Tosh said, look, man, these people said X, Y, and Z about you. I had to cancel you. What was I going to do? Carry a show with you? They're talking criminal charges? Like, I wonder if during this entire conversation that involved the breach of a contract and the mending of a contract, if at any time maybe Chris Tosh specifically told the plaintiff that he terminated the contract based on something that the defendants did. I wonder if that happened. Oh, I hope they get to the bottom of this. Because I have a feeling that Lemoyne's probably right. Tosh probably told Vic, I canceled your... Or wait, that's Tosh. I canceled your contract because of something unrelated to the defendants. And that's why I did it. So here, take my affidavit and you sue the defendants based on it. I'm betting that Lemoyne is right here. I bet there's no way in hell that Tosh told Vic that it was because Ron Toye and Monica Rial said he was going to jail. I bet that's not why, and that there's no way that that happened. It was definitely, Tosh said, I went to a fortune teller, I got a bad hand job, and that's why I uninvited you. By hand job, I mean palm reading, YouTube. Don't you dare algorithm me on that. I don't mean the sexual deviancy that your disgusting monetization team is thinking of. I mean a palm reading. That's literally a hand job. It's a hand that gets paid. You get hand jobbed at psychics all day. I'm going to open a psychic shop. $5 hand jobs. I will be the best-selling psychic on the planet. Don't at me, psychics. You saw this coming. You knew what your profession was. Whores. All right. All right. On we go. On we trudge. It's like a Minnesota winter up in this piece. Okay. Listen to the logical leaps that this moron has to go through to even sustain some semblance of an argument about why he's got to depose Latenight. He has to assume the opposite of the most likely reality is the real one. And like, he takes Occam's razor and he gives it to an emo kid, as dangerous as that is. But that's how careless Lemoyne is with the truth. He also hates children, I've heard. I've just heard this. I can't verify it. And so we want to take his deposition, and I think it's a fairly short deposition. Maybe 2 hours. It's 2 hours? Tosh, why did you cancel these guys? Because your clients told me to, because they threatened me. And they said they threatened to pull their money out. They threatened to pull artists out. They did pull artists out, and they said that Vic was going to jail. What? 2 hours? 5 seconds. 5 seconds. This is all it takes. Read my affidavit, bro. That's why I canceled him. It's right there. Just read the affidavit. To find out in part why he breached the contract, and in part to find out how this affidavit that he allegedly signed in Ector County but was notarized in Smith County came into being. This was actually explained at the hearing. It was actually explained. Do I have it? Do I have it handy? Let me see if I've got it handy. Hold on. When was this? It's a date on this thing. Oh boy, what do we got here? Okay, let's see. Whoops. Hold on. I want to bring up the. I want to proof up what I'm saying, like a good Bible scholar or whatever. What do we got here? Here we go. Here we go. Transcript. Let's see. Let's just find it. Let's find out if maybe at the hearing, We've got... Let's see. Let's see. I'm trying to find out if they covered the affidavits. I don't think they want the affidavits considered. No, they don't. Right. Because they're devastating. Let's see. Let's see the... I want to see where he talks about... Let's see. Let's see. Notarization. Here we go. Gosh, Chupp is such a cock at this hearing. It's amazing. Where is it? Oh, wait. Doesn't... See if I can find it. Okay. What was the issue with the notary? What was the issue with the notary? It's almost as if this is explained right here in this part of the hearing. Okay? And I've talked about this before. That's why I was pretty sure it was in here. And lo and behold, it is. It is. What was the issue with the notary? I was the notary. This is from Mr. Beard. And I thought I could notarize based on a telephone call, knowing the affiants, and that turned out to be wrong. And so Lemoyne flips out over the notary thing. And the court just says, okay. And then note, again, this is Chupp and the problem with not ruling on this stuff. This is a problem. And this is one of those oversights. This is an oversight by Ty that I assume will probably never happen again in Chupp's court, because Ty knows that Chupp isn't going to rule on things, right? Or maybe it will happen again, but I'll probably consider the affidavits as far as your response, but not your new pleading, not your second amended petition. That's obviously you're trying to get around the rules. I mean, so I have read them. So, I mean, I know what they say. It's going to be hard for me to put them out of my mind now that I've read them anyway. Notice what he did? Notice what he did. To sustain his position, he had to ignore the affidavits and the unsworn declarations. He had to. He had to not consider them. But at the hearing, he said he was going to consider them. In his ruling, he said he didn't. And that's the problem. If they get those affidavits in at appeals, Lemoyne's lying when he says that they don't go far enough. He knows they do. Chupp knows they do. But that's what I want to point out, though, is Lemoyne keeps saying, we don't know how they were notarized. Ty said it at the hearing, on the record. It's in the transcript. I was a notary. I thought I could do it over the phone because I know the affiants. Turns out I was wrong. That's it. End of story. You can call it whatever you want. You can call it notary fraud if you want to. That's not accurate. Notary fraud would be an intent to deceive, whereas there's no reason. Like, there's no benefit to having a notarized affidavit versus an unsworn declaration. It's literally just a boomer mistake. And that boomer mistake can't be classified as fraud. Now, whether or not that boomer mistake is devastating to the case, obviously in this case it was. Now, the appeals court may fix that. They may not. And if they don't, then that's a big problem. That's a big problem that will have to be worked out between Vic and Ty. Absolutely. I'm not trying to mitigate the fact that that is an annoying and stupid mistake, should not have been made, but to keep, Lemoyne has consistently misrepresented the court that what happened to notarize those affidavits is somehow a mystery, but it's on the record. And man, do I hope that Martinez, Ty, Onley, whoever's in front of the court tomorrow brings up the fact that this is in the court's record and has been consistently misrepresented by this wheezing failure of oxygen called Lemoyne. He has lied to the court. We don't know how it was notarized. It was notarized by me over the phone. I made that mistake. And by the way, the remedy for like a faulty document that's not fraudulent, again, they have no evidence of fraud. There is no fraud. The unsworn declarations are substantially identical to the affidavits. The assumption, the Occam's razor assumption would be that plaintiff's attorney just screwed up on what was required for the notary. He wasn't boned up on his notary. That's it. That's the Occam's razor assumption. Other than that, to overcome that, you need something. You need to show some evidence of fraud, but that's dispelled by this unsworn declaration that's there. And the fact that the affidavits all had the same defect, that they were all cured in an unsworn declaration, kind of lends some credence to the idea that that was fixed. Unless they're saying all the signatures are forged. What evidence do you have that they were forged? What evidence? That much evidence. They're grasping here. Gasping, wheezing. So we know how the affidavit was notarized in Smith County. Now, funny story. If Ty were trying to defraud the court, okay? Think about this. If you're a lawyer attempting to present a fraudulent notary, or not a lawyer, but you're a notary attempting to present a fraudulent notary, when the client or the affiant signs their county as Ector County, why in God's name do you sign your notary in Smith? By the way, this is another razor. Hanlon's razor, right? Occam's razor, the simplest explanation, is often the correct one. Hanlon's razor, never attribute to malice that which can be adequately explained by incompetence. If Ty wanted to defraud the court, he would have notarized the documents in the same county where they were signed, because that would be a much harder fraud to debunk. You'd have to convince the court that he didn't go there and notarize the document. You'd have a hard time doing that. You could certainly try, and they tried to lay that out with how he couldn't have traveled from here to here and all this stuff. You could do that. It's a much harder thing because you've got two people saying they were in the same place signing the document. A good fraud, even a barely competent fraud, any fraud would have had the matching county names because the affiant signed the document before. Or if you allege that they're fraudulently signing the whole thing, that they're forging everything, why in God's name would they screw up having two different counties? You just say they were both in Smith or they were both in Ector. It doesn't make sense. It doesn't make any sense. So, but there you go. So Lemoyne is really reaching here, which is dangerous for his health, and he should probably stop doing it. But that's where we are. So we're never going to get through these documents because I'm going to whiskey tangent on all of this stuff. The court. Okay, but I don't think I can sanction somebody for filing after the petition necessarily. I mean, my sanction is to try to prevent people from filing these types of lawsuits, not necessarily their response to the motion, right? And so it seems to me that the evidence that you're trying to seek from this guy, I've already ruled on it in that I dismissed the case. Chupp's right. I mean, he didn't do it correctly, in my opinion, but this is what happened. At least he has some situational awareness. Ryan K says, notary fraud would be trying to submit an affidavit in the name of someone who never intended to submit one. Like if Sabat was to suddenly provide Vic an affidavit, that would be suspicious, worthy of possible fraud. Yeah, I agree. That would be, again, fraud is a crime of intent. You have to intentionally mislead or lie or misrepresent. Not just misrepresent. You have to represent the opposite of truth for the purpose of obtaining a benefit. There's no benefit to be gained from an affidavit over an unsworn declaration. There isn't. They're legally identical. That's what's such a weird part of this ruling. But Chupp ruled from the bench in ways that he knows are problematic. Even without the affidavit, Chupp's got a problem on the TI with Ron Toye. Even without the affidavit. And he's got a problem with Markey. That's in the record, by the way. He's got a problem with Markey based on his conversation with Sam Johnson on defamation. He's got a problem with her there. And he knows this. Chupp knows this. But that's why he wrote the order in the way that he did. Erica McCord challenged me to match again? Y'all are rude. Erica, that's rude. Another 200? Let me think about it. Let me think about it. I think it's probably going to happen. Here's my challenge. Will the chat also match my $200 donation? Along with Eric. So, or Erica's $200 donation. Will the chat help me out there as well? I'm not going to hold the chat to that challenge, but I will request it. I will throw down the gauntlet. I will put the 200 up. I'll do it right now. This is my last one, guys. This is my last one. I donated $750 at the beginning of this campaign. This will bring my total today to $700. But I will match it. But this is the last challenge for me. Because at the end of the day, I have to feed 5 children. Let's see. You don't get another donation, GoFundMe. There we go. This is such I'm terrible. You guys are rude. Oh, but I get paid today, so that's helpful, at least. That lessens the sting. Here we go. Confirm. Yep. Back to campaign. There it is. There it is, chat. $200 more from Nick Rekieta matching Erica McCord's throwdown challenge. Now, I challenge the chat not to match at 200 individually. 10 donations of 20, 20 donations of 10, 200 donations of 1, however you want to do it. And by the way, we've given GoFundMe a lot of money on this channel. Feel no obligation. You can change their donation amount to 0 if you need to. Yeah, can you guys match Erica and I at $200 as a collective? As a collective, that's my polite, very prim gauntlet throw. Match me, bro. Match me, bro. Nickelback is great. I have lungs at work. I'm good at lying. Okay. JCF data. Oh, wait, no, I missed Brian Dewig. Brian Dewig says, it's a shame for our lemon-headed friend that everything they say is recorded in court. Oh, it is a shame. It is a shame. JCF data says, helping Erica with the challenge to Nick. Also, if they let Tosh be depoed, would that not maybe be good things in the record for appeal? It might. It might. It might be good things. Super Saiyan Surg, I can tell Ty, thanks for helping Vic. But I will have Ty again, on again soon. And you can also come tell him yourself. So, just so you know. Post link. Post link. Link to what? The GoFundMe? There you go. GoFundMe is locked. Which one? Whoa, we've got Brian Dewig and Dominic Lusso and Anonymous also donating. Let me read through a couple of these that I missed. T. Greg is bankrupt. Thomas Wakefield, Erica McCord, Mark Mariansky, James Burke, James Powers, Nick Rekieta, Brian Dewig, Dominic Lusso, and Anonymous. Thank you all for donating. You guys are fantastic. We're at $5,500. We are really close to doubling the amount that he had at the beginning of the show. That's amazing. You guys are crazy. Crazy. Oh my goodness. Oh my goodness. Yeah, like Heath is I'm gonna force him to come on again. Even though you guys kind of picked on him, which is okay. It's okay. Everybody needs a little picking here and there. I'm gonna force him to come on again and thank everybody. It'll be great. It'll be great. Teach your kids to READ. Okay, back to the document. Get to the chopper. Let's see. My sanction is to try to prevent people from filing these types of lawsuits, not necessarily their response to the motion, right? Ooh. Chupp just brought up a good point on the sanctions. And so it seems to me that the evidence that you're trying to seek from this guy, I've already ruled on it in that I dismissed the case. I would disagree, Judge, in that there's only a couple of cases that address what the court should look at in TCPA sanctions. As the court points out, it's a deterrence argument. Deterrence of filing a lawsuit. Chupp is actually making Lemoyne look like the amateur on the TCPA here, because he's just reading the statute. And I mentioned this before. Lemoyne is trying to conflate the sanctions, the statutory sanctions of the TCPA, with a quote-unquote bad behavior sanction that would be issued by the court for cause for bad behavior of an attorney or a party in a lawsuit. These are different things. They're different things. Just because they both say sanction doesn't make them both sanction. Teach your kids to Chupp. You guys need to stop. I'm dying. Okay. That's correct. Deterrence of filing a lawsuit. That's correct. Right. But one of the things that goes into that analysis, I have to imagine that that Lemoyne pronounced it analysis, because the one court, it's the Landry's case out of the Houston Court of Appeals, said because deterrence is a component of the TCPA, we look at Chapter 10 and we look to Rule 13. Why did they look at it? What does the Supreme Court tell us to look at? Oh, stop. Stop being Socratic with the court. Just tell them.
One of the elements is frivolousness. The other one is vindictiveness of the complaint.
There is no vindictiveness or frivolousness in this complaint, by the way.
So I think under those two arguments, we get to take his deposition. Because if he comes back and says there was an affidavit that had me blaming Miss Rial and Mr. Toye, and I said I won't sign that. And then you have this very odd plaintiff, I breached the contract admission. It's a liability, you know, just kind of where you would say I breached because of what they did.
This part of his argument makes no sense. Odd plaintiff, I breached the contract admission. So he's literally saying what the court asked for in Kahn versus Vanderlinden is odd. We want a TI, someone who breached under TI, want the breaching party to say that they breached. That's what we want the breaching party to say. I breached because of this. So they produce it, and then he says it's weird. It is weird, by the way, for the breaching party. There are TI cases in Texas, Knox v. Taylor is one of them, where they say they don't really listen to what the breaching party says so much because the breaching party is motivated to not tell the truth most of the time. Because they breached a contract. Now, this was in the alternative when you have a hostile breaching party, hostile to the plaintiff, not hostile to the defense. When you have a plaintiff and a breaching party who have resolved their TI issue in a separate matter, it's not super uncommon because it's a resolved matter for the breaching party to then say why they breached. Yeah, we breached because of these things. We rectified it. We came to a negotiated settlement, but we did breach. But now probably part of that negotiated settlement is an agreement to drop all existing claims. Like that's part of settling lawsuits, right? Anyway.
I think we should be able to depose him and find out the information around that.
Notice they have, if he comes back and says there was an affidavit that had me blaming and I said I won't sign that, there's no indication that this exists. None. Zero. Lemoyne made this up out of thin air. He doesn't have like an unsigned copy. He doesn't have anything about that. He doesn't have any indication. He hasn't produced an email from Tosh that says, well, I was uncomfortable with the language of the affidavit. He hasn't shown anything to support this argument. Okay, the court says, but you should have deposed him before the hearing then.
Judge, I would disagree, and here's the reason why.
Well, you filed the motion. I mean, you said they didn't have a case, so you filed the motion. You thought you had enough to get there, and you did. I mean, I ruled your way, and now you want more evidence to show that you should have won. He's trying to relitigate this issue. This is a big mistake, I think, by Lemoyne. Lemoyne's opening the door to put more on the record to bury his own case. And he is arguing to Judge Chupp that Judge Chupp still has jurisdiction over his ruling. That's what he ultimately has to argue here. If Chupp still has jurisdiction over his ruling, Chupp can change it. I hope. I don't have that much faith in humanity left, but I would love for Chupp to reverse some of his own decisions on this. God, that would be the funniest possible outcome. That would be the funniest possible outcome if Chupp reversed himself because Lemoyne pressed. And Chupp said, well, maybe, now we have evidence to say we got to reconsider. That'd be great. The court says, No, Judge, I want evidence to show they knew it was frivolous when they filed it, which is different. This is a crucial indicator from Chupp right here. I don't think they knew. I don't know that they necessarily did. But I mean, I think they got caught when they got here. Look at how Chupp is wording this. He is not saying their lawsuit was frivolous. He's implicitly saying they got tripped up on a rule, on a technical rule. He is not saying that this lawsuit is frivolous. But I mean, I think they got caught when they got here. And if what you're saying is true, they tried to fix it. But Judge, you're going to ask him questions and prior to filing the lawsuit, not after filing the lawsuit. I don't know what that means there. But look at what Chupp is saying. This phrase should terrify the Kick Vic side. This is one of Chupp's subtle clues. I don't think that they thought this was frivolous. I think they got caught when they got here and they tried to fix it, but I stopped them from fixing it by denying the admission of their second amended petition and the unsworn affidavit, the unsworn declarations. It's right there. Chupp not flat out. Sorry, that's the liquor talking getting me excited. Chupp implicitly states that those unsworn declarations fix the problem. And that he let Lemoyne and the defendants off on a technicality. That's a very, very dangerous place to be. And in my motion on the appeal, I would be hammering this segment of the record from Chupp. I would be pointing out, we have a valid case. They're trying to win a meritorious lawsuit by claiming it's unmeritorious because of a technicality, not because it actually lacks merit. This is against justice and against the purposes of the TCPA. I would be hammering that home at oral argument. Court of Appeals, this court's job, it's commissioned under the TCPA to find justice, and we are to reach an unjust result based on a hyper-technical reading of a rule. We're supposed to reach an unjust result for a plaintiff based on a hyper-technical application of a set of rules with no authority to support that hyper-technical application. Not even plain language support from the statute. Just a hyper-technical application made up out of thin air. This should terrify Kick Vic. Mark Whipple, make sure you accurately quote me, you lame sack of trash. This should terrify them. And here's the reality. I think they know it. And if they don't know it, they're frankly bad lawyers. That's really where we are right now. The reality of the situation notwithstanding, they know that if those unsworn declarations are considered by the appeals court, they are fisted. They are fisted on this. Chupp's saying it right here. He's going to say it again in this hearing. Because that's the evidence that's relevant is at the time of the lawsuit. Was it frivolous?
I'm not sure that I believe that.
Well, you don't have to believe it.
But I don't know what communications he had with them. I do know that text messages between Mr. Slatosh and Mr. Toye found themselves into the public media arena before the lawsuit.
They're also in the record. Those aren't excluded.
I believe before the lawsuit was filed, which means, and I believe that either Mr. Beard or somebody with Mr. Mignogna's legal team had already talked to Mr. Slatosh.
Oh my God, you think they had already talked to Mr. Slatosh? Lemoyne. They got Vic readmitted to Kamehacon prior to filing the petition, right? How brain dead are you? Of course they talked to Slatosh prior to the filing of the lawsuit. Of course they did.
In fact, I believe there's a non-disclosure agreement between Mr. Mignogna and Mr. Slatosh that was designed to prevent him from talking to people.
Well, yeah, sometimes when you settle things, there's a non-disclosure agreement. I believe that to be the case as well. I don't know if it is, but I know that they settled their dispute and Vic went back to Kamehacon. I can only assume there's a non-disclosure agreement around it.
And so to that extent, if this court is focused on the temporal, kind of what did they know before they filed the lawsuit?
You could see him like explaining this.
My guess is they knew, and they had already had this conversation with Mr. Tosh.
So your assumption is that not only did they know what Tosh was going to say, they had just reached a favorable conclusion on the Kamehakon saga and later procured an affidavit from him. And your conclusion, your big brain thought, is that Tosh said something opposite of what's in the affidavit. That's, wow.
The fact that the affidavit was signed after the lawsuit was filed, I can ask him that. Who did you talk to? What did you tell them? What did they ask of you? I mean, Mr. Tosh's affidavit even says I was pressured into letting Mr. Mignogna come back under threat of a lawsuit.
Yeah, he breached a contract, you weirdo. Does he not understand? I don't think he does. He's making the TI case right now to Judge Chupp. He's just flat out making the TI case to Judge Chupp. He says he was pressured. Why? He says in the lawsuit, I was pressured to breach a contract. I did breach a contract. I was then pressured to bring him back. We settled it, and I brought him back. He's just making the TI case for him. Here's the dumb thing. If Chupp reversed on just the TI, that would be an abomination. That's the annoying thing with how the TCPA is written. That would probably be more detrimental to Vic, outside of the morale thing and letting people know that these scumbags actually did do this to Vic. That would be the positive, right? The negative would be they'd have to litigate the TI and then appeal everything later. That would be annoying. That would be really annoying. And that might be the one thing that prevents Chupp from doing it, is saying, well, he could undo the TI, but he's not comfortable undoing the rest. The appeals court will address all of it. Or the appeals court has to wait until we do the TI to then address all of it. And Chupp will have to sit there in his court knowing that there is a legitimate case for defamation. There is a legitimate case for civil conspiracy, but they're just hearing the TI, and then he's going to have to hear it again. That's a terrible prospect. It would take forever. Because litigating the TI is going to take 6 months. Although there is benefit to it. I'm not saying Chupp shouldn't do it. I'm saying there's a problem if he does. Okay. Chupp says, I mean, oh, this is devastating. Look at this line. I mean, seems like you're not real confident of what the appellate court is going to do. Ooh. There's another clue by Chupp. Hey, man, this might be coming back. Might be coming back. That's a bad sign for Lemoyne. Kick Vic should be really scared of this. And they should pay attention to how Chupp talks about the appeals court in a little bit. I actually, I mentioned this when I first said what happened at this hearing, but all I had was a secondhand account. And not that I disbelieved my source, but people hear kind of what they want to hear, and they might hear things in a different way. And I did hear some things about the hearing that I don't think are 100% accurate based on the transcript. I didn't talk about them. I was assured that this was in there. I still hedged it when I mentioned it, but here's Chupp saying, seems like you're not real confident what the appellate court's going to do. And that sure seems to be the case, doesn't it?
Mr. Lemoyne, I am confident of what the appellate court is going to do regarding the dismissal.
This is a weird lawyer. Like, we could take this as the lawyer answer. He could be confident that they're going to bring it back. I don't think that's what he's saying, but we could lawyer that. The court, yes. Maybe they do know. Maybe they do know. Chupp, I think Chupp knows what's going to happen here. He's indicating he thinks this is coming back. He's done it here, he does it above, and he does it below, too. We'll get there. Mr. Lemoyne says,
what I'm not confident on is the situation. It's a sanction. Because the Texas Supreme Court has not ruled on what elements you're supposed to look at. And neither has the Fort Worth Court of Appeals.
This is a bad position for Lemoyne to be in. Because that means the Fort Worth Court of Appeals makes the sanctions issue ripe. They're gonna take a look at this case. Even if they ghost on the claims, they're really going to look into the sanctions. He's not confident in how they're going to do it because there is no guidance on it. That's not a good place for them to be, because that means they're going to look at the case. They almost have to. This is a novel issue before the court. What they say about this sanctions hearing is going to resonate into future TCPA cases. Blackberry Jim says, last one. Don't tell Chupp the babysitter's dead. Skaki Onsai says, as Lemoyne,
you may ask yourself, what is that fat GoFundMe? You may ask yourself, where did my inhaler go to? And you may ask yourself, am I right? Am I wrong? And you may say to yourself, my God, what have I done? What have I done?
So there you go. All right. The court says, you've already filed your attorney's fees motion, right? That's correct. Chupp, come on. I didn't look at it. But how much are you asking for? You didn't read it yet.
I believe we were asking for $259,000.
And you want sanctions on top of that. You can read how he says it however you want, but I'm going to base it off of his next line.
Yes.
Okay, I mean, that seems like a lot of money.
It is.
Mistake. This is a mistake by Lemoyne. That seems like a lot of money. Now Chupp's going to be curious. What's in these filings? Maybe not. Chupp could be curious. What's in these filings? What's in this bill? That's a lot. That's a lot of money. I've seen your work product. That's a lot of money. 260 grand? For what? What did you do? I want to find out. I want to find out how that bill is so high. Now, maybe Lemoyne won't do anything, right? Not Lemoyne, Chupp. Maybe Chupp will chup it up. But there's an indication here that he might be interested in looking at that bill. And then on top of that, you want sanctions on top of that? That's a lot. Might be enough of a deterrent on its own. I mean, that seems like that might deter somebody.
Well, just paying my client back is not much of a deterrence for an individual who crowdfunded his own litigation fees and didn't incur,
I hope he said incur,
any economic pain to bring this lawsuit.
This isn't true, by the way. That's not true. He still had to pay his attorney. That money could have gone to anything else. Could have gone to a new project. He could have individually started a thing and done a GoFundMe for that. All sorts of things could have been done with that money, but it went to this. Wait a minute. Is that a GoFundMe mention? I think it is. I think that's a GoFundMe mention for Vic. We've got $261,773 of angst and depression for J. Sean Lemoyne. J. Sean Lemoyne tweets out this GoFundMe amount every night like an obsessed pedophilic weirdo. I said like, it's a simile. I'm not calling him that. It's a simile. He tweets it out every night before he goes to bed.
$261,100.
Or whatever. Tweets it out. Here it is. 261,773. Tell you what, guys. The liquor and tea are hitting me, and I need to go to the restroom. So let me leave you with the sweet look. Look at those eyes. Those green eyes piercing. The butt chin looking at you invitingly, saying, "Help me. Help me. I don't know what to do. I've had my career ruined. And it's not fair. It's lies." That's true. It's lies. It's lies, it's lies, it's lies. So you guys hang out with the GoFundMe for just a minute. And Chaircoon will take over the show. I'll be right back. Who's mad? That is the second unprofessional disappearance from the stream. I apologize. I hate leaving the show. I hate it. But duty and nature called. So we are still at $261,773. According to this, it may be updated. We'll check back on it in a little bit. We've got donations from Davian Bowens. Thank you so much. Anonymous, and Tom Young. Thank you guys for donating and contributing. We will keep an eye on that as we go. It's annoying managing the shilling of 2 GoFundMes. Holy cats. Before we get back into the flow, I just want to make some thanks for Mr. W's Classroom Library has a couple more donations as well. We have Matt Fields. We have Davey Johnson. We have Jameson Oceant. We have Ramon Franco. We have James Ketter, James Fleming, Angron Deshea. Come on, man. I love it. We have Anonymous, and we had Jordan Rankin. And Angron is the $8 a reference to the Eightfold Path. I just have to know. Thank you guys so much for donating there as well. I just happened to check on it before clicking over. Nothing is over. All right, back to the documents. Here we go. Well, see, that may be more relevant than what he and Tosh did. And it is. As far as the sanctions go, Chupp is right here. The GoFundMe and the attorney's fees amounts and all that stuff is more relevant than Tosh. Are they relevant? That's an open question. They are more relevant. Relative to Tosh, they are more relevant than him. I don't know if they're ultimately relevant here. There's still economic pain. You still have a guy at the end of the day who was thrown out of his career based on lies. And oh my God. They subpoenaed Vic. Good luck with that. Just let the man sit on the stand and say, they lied about me and it ruined my career. And it's made my life a living hell for a year. based on their lies. What was I supposed to do? Just let the man say it over and over again. That'll be good for the record. I was talking about those mistakes that I think people are making. I think Lemoyne's making a big one in doing an evidentiary hearing on the things, in subpoenaing Vic, trying to get Tosh's deposition. He's just begging to have stuff added to the record, which he is saying is not complete for the purpose of appeals. And at appeals, he's going to try and argue that it wasn't in the record beforehand, even though it kind of was. But Vic will get up there on the stand with those big gay pants, and we'll see. I don't know that this is going to go the way that Lemoyne thinks it's going to go. Okay.
Well, it's certainly relevant to the economic component, which was part of the ability to pay the fees and things like that. But I think from the standpoint of the Court of Appeals looking and saying whatever sanction you impose, there's no doubt they're going to challenge it, the dollar amount.
Yeah, of course they're going to challenge it because it's whatever you say is wrong, Lemoyne. So they're going to challenge that.
If the Court of Appeals is going to do the analysis, the very first thing under Chapter 10 is whether or not the motion was frivolous. The fact that we won doesn't automatically mean the motion was frivolous.
He just admitted it.
Or that their lawsuit was frivolous. It means they didn't meet their evidentiary burdens.
Oh, Lemoyne! You flat out said it. You just said that it's not frivolous just because you won. T. Greg is literally wrong. Oh my God, how embarrassing for T. Greg that his boyfriend just called him wrong in court. Because T. Greg has been saying that because of Judge Chupp's ruling, that it's a meritless lawsuit, and then as a matter of law, what they said about Vic was true. Of course, this is a retarded legal analysis. And by retarded, I mean the French usage of it, which is retarded. And you can ask JF Garipe what I mean by that's a joke. That's mean. You can just figure out what I mean by that. It's absolutely ridiculous to suggest that because of a pretrial motion failure, that what they said wasn't defamatory and therefore was as a matter of law true. That is the most amateurish and stupid legal analysis you can find. And hopefully one day the lightning bolt that is looking for Greg will strike him. In Minecraft. It means they didn't
meet their evidentiary burdens. I'm not asking for, 3 people submitted affidavits from their side. I'm only asking for this gentleman because he was kind of the centerpiece of their argument.
That this is also flatly untrue. He has subpoenaed Vic to testify at the hearing. So he's literally asking for 2 of the 3. And the only reason he's not asking for Chuck Huber is because Chuck Huber's affidavit is basically garbage. Chuck Huber's affidavit is great to talk about what a cesspool Funimation is and how much of a giant cockbag and a degenerate asshole Chris Sabat is. Chuck Huber's affidavit is great at pointing out that Chris Sabat is a sexual predator with a casting couch. Those are Chuck Huber's words, of course, not mine. Reminder that Chuck Huber called Chris Sabat a sexual predator with a casting couch that made casting decisions based on sexual favors, which shockingly I think could be backed up by evidence if Chris Sabat wasn't actively suppressing all of that evidence and doing whatever the hell he can on earth to shut up the women that he demanded sexual favors for in exchange for roles. I mean, ignore all that. As far as this part of the case, Chuck Huber's affidavit is tangential to the case. And great. Whatever. Thanks, Chuck. You wrote your affidavit like a cockbag, if I'm being honest. I think you know that, though. And you've been very wishy-washy since. You've been calling the people who you claim had a casting couch and ran the company as a Kafka-esque nightmare good people, Chuck. Examine your head, buddy. Get in the right headspace. You're either against bad people or you're not. I, for one, fully welcome my casting couch overlords. Put me on the couch next. Let me present myself in prostrate. Gross. Credit to Chuck Huber. Because I picked on him just now. I feel like I should give him just a little bit of credit. I think he maybe wasn't thinking at all about what he was saying. Because I think he's scared as hell of what these people will do to him. Chuck, they're bad people and you know it. Just tell the truth, buddy. Tell the truth and run away from them. They're bad people. They're not good. You know they're not good. You said they weren't good. Don't backtrack. Stand up like a man and own it because you know it's true. Anyway. Sorry, that's my personal tangent, and that's the Corner Creek slipping through.
And Judge, their argument basically is cost, right? If we get past the should I ask for leave, we're really talking about whether or not the deposition is appropriate.
Yeah, that appropriate as in you should ask for leave. You didn't do it.
They have 4 attorneys here trying to tell you that it is costly to allow this deposition, and it shouldn't go forward. I think the fact that 4...
Objection, Your Honor.
Attorneys are here.
Hold on. A number of attorneys here is irrelevant to his argument as it relates to that. Martinez is right, of course. This is irrelevant to the argument. F says, would you be inclined to believe the only reason Funimation, whatever her name is, didn't back down when threatened with the lawsuit is because they think there's a whole corporation against one person they can't lose? Oh, absolutely. Absolutely. Well, I mean, overruled. No, so Chupp doesn't... I've noticed this. I don't know that Chupp has sustained an objection in this entire case. He's overruled or ignored the objections. In fact, he told Ty to stop raising objections. That alone might be reversible error. That is insane. Stop standing up and objecting. Oh my God. A lawyer can object as much as he wants as long as those objections are founded. He didn't say they were not well-founded objections. He just said stop doing it. Chupp overrules and then agrees with the objection a couple times throughout this suit, but I don't think he sustained a single one. Well, I mean, overruled. I mean, I'm not necessarily considering that, so that's okay. Keep going. So he agrees with Martinez, but he overrules him, which is just weird. Just sustain the objection, you weirdo.
I think that's one of the pieces of evidence that you need to take a look at in terms of whether or not their lawsuit at the inception was frivolous. It's irrelevant, and they're all blocked in over what Mr. Slatosh is going to say. They should welcome the deposition.
You should be scared that the deposition will go their way, Lemoyne.
They shouldn't be opposed to it.
Well, but of course they should be opposed to it because you're raising it. That's your actual argument, by the way, is that because people are objecting to it, that it's got merit. So they should object to it.
And they shouldn't have 4 attorneys here telling you that I ought to be sanctioned. We don't need to hear any of this evidence because it means nothing.
So you are, I guess what you're trying to tell me is that 27.009 with regards to damages and costs contemplates additional discovery after a ruling, because I guess there could have been a situation where I did it all at once, right?
That's correct, Your Honor.
And then what would you have done? We would have been stuck with what you had, right? So how come you get to have additional evidence after the hearing, but they don't? A good question.
So 2 answers, both of them wrong. First, I would have, in order to be able to have any defense at the Court of Appeals about attorney's fees or sanctions, we have to have an evidentiary hearing.
Nope, you could do it on paper. You don't have to have a hearing, and you know that. Right.
So if I come to the court and I don't ask for discovery to have the evidentiary hearing, I wouldn't have an argument.
Yeah, you would. if they don't contest it at an evidentiary hearing, then you don't need an argument. It's presumed true. So this is silly. And this is actually a little misleading because a lot of times attorneys don't contest the other side's attorney's fees if they're reasonable. They're reasonable. They don't need to contest them. Now in TCPA, of course, it's going to be different because TCPA automatically awards attorney's fees as a statutory measure. So they're going to have to mitigate them as much as possible. But anyway.
Which is why I'm here ahead of time, so that I can say to the court, I'd like to take this guy's deposition.
If you could, if Tosh was within the subpoena power of this court, would you actually have him at the hearing to testify at the evidentiary hearing?
Yes.
And you're not able to subpoena him because he's outside of the 150 miles to come here?
That's correct.
So you're trying to do this deposition so that you can secure his testimony for the hearing?
That's correct.
That's a better argument. It is a better argument. Chupp doesn't say it's a winning argument, but he says it's a better argument. Okay, he wants to bring this guy down here to testify, but he's outside the subpoena range, so why can't he depose him? I don't know which one of y'all is doing this today, but why should he not be able to bring that evidence in here at the hearing? Well, Your Honor, I believe Michael Martinez on behalf of Mr. Mignogna. Yes. Your Honor, I believe the court hit the nail on the head here when you said as an initial matter that if he wants discovery, he has to come forward before the court before he goes off and files it, and then files a motion to compel, causing my client to have to file a motion to quash and then a response to that motion to compel as well. From that perspective, moving beyond that, Your Honor, I feel like this voice is doing a discredit to Martinez, who's making a good argument here. But beyond the procedural aspect of this, my opposing counsel here makes a valid argument for the standpoint where he says he has to have evidence to put forth for the Court of Appeals. However, the evidence that is necessary, that is available for him to put forth before the Court of Appeals, is the evidence that was presented or offered to the court at or before the time of the hearing and at or before the time the court granted the motion itself, anti-SLAPP motion, and the TCPA motion. Oh my, I don't think I can do this. It's too slow. It's too slow. You guys made me do this. You did this to me. I didn't want to do this. Dustin Fritzfar says Chair Coon is a good name for a chair, but I prefer my chair's name. Chernabog, Throne of the Underworld, and Greater Demon of the Nine Hells. F says, shouldn't it be Chair of Baal? Like, that's a Eisenhorn's reference, right? Chair of Baal? A Chair of Baal? Oh, God. I got to name Chair Coon Chair of Baal. Chair of Baal. F says, would you be inclined to believe the only reason Funimation, whatever his name is, didn't back to... Oh, I read that one, but I just missed the Chair Coon from Dustin Fritzfar. Dustin, I apologize for missing that earlier. Siren Jag says, Old Bag... Oh, as Old Bag. Get your hands off me, Lemoyne. Not one of your regular girls. Hey, I thought a good name for a prostitute. Take your mom's last name and put a first name in front of it. Ta-da! Wait a minute. Rekieta. Weird. I don't get it. Okay, I've got to stop the Slowpoke Rodriguez. I have to stop it, otherwise we're never getting through this. Mr. Martinez is making a great argument here. Look, he has to have evidence for the Court of Appeals, but he should have done that at the hearing. He should have presented all of this evidence at the hearing, and he didn't do it. That's Martinez's argument. Whether or not he's right, it's a good argument. Everything is stopped at the hearing. Because in theory, Chupp could have said, okay, I dismiss everything at the hearing. And I want to hear your fees. Give me your fee request now. My mother's first name followed by your mother's last name. That's not a good name for a prostitute. Your Honor, I gotta read it normal. I'm sorry, the whiskey. The whiskey is forcing me to do it. He says that he has to have this information. And as Your Honor pointed out a moment ago, always reference the judge's words. This is something that he says he had the opportunity to do so because he hasn't been able to bring Mr. Slatosh to Tarrant County to testify. He's trying to get around that by doing a deposition. Notice this is Lemoyne's argument and the defense's argument about those unsworn declarations. Oh, you should have done it sooner. Let's come back to bite him. Everything he is doing now, Your Honor, is the exact same thing that he could have and should have done if he says it is vital to his presentation of evidence. Something that should have happened prior to the hearing. Now, Lemoyne admits that he thinks that Ty talked to Slatosh prior to the lawsuit being filed. He went ahead and admitted to this argument ahead of time. He made the argument. He knows that Ty talked to Slatosh prior to filing, that the text messages were released to the public. It's not like he discovered this later. He knew, and he chose not to act on it. This is Martinez's argument. Will it win? I don't know. But is it a good one? Yeah, sure. Everything... wait. He is attempting to take, essentially, Your Honor, a closed book because the court has already heard all of the evidence that was necessary to make a ruling on the TCPA motion and reopen it to add additional evidence, try and show additional things that may or may not have even occurred. He's provided no factual basis to or any type of evidence whatsoever that is admissible to the court to justify any of the things that he says, other than his conjecture today, where he says, we believe that Mr. Slatosh may say this, or we believe that Mr. Slatosh may say that. None of these things are supported by any type of evidence whatsoever been put before this court. Additionally, Your Honor, what he is trying to hear is the affidavits weren't even considered by the court. They were withdrawn in this instance in their entirety prior to the hearing, and the court stated on the record and within its order granting the TCPA motion that the affidavits were not considered. So if those affidavits were not considered, then what does it matter that they have to have them suddenly go back and find out other things that may or may not have occurred from that perspective, Your Honor? He's setting up the stage for them to admit the affidavit, I believe. That's what I would be doing. Let's see. Additionally, Your Honor, as we're going through this, he says that this isn't about fees or, this isn't about driving up costs, et cetera, et cetera, et cetera. At the end of the day, Your Honor, unless he's going to come back to the court and say all the fees associated with trying to obtain the deposition of Mr. Slatosh are not going to be included in his claim, it is about the fees and it is about the cost. Regardless of whether Mr. Mignogna's counsel appears at the deposition, this is what I said earlier. There's still going to be additional costs incurred. There's still going to be additional costs and that they've already covered in the request. So when you look at it from that perspective, Your Honor, any evidence that they wanted to put forward as part of their TCPA motion should have been presented at the TCPA hearing. And that's just, it's purely at that point, okay, I'm not going to let you do the deposition. Chupp is clearly convinced. he's okay. I'm not going to let you do it. I think that it's just going to confuse everything if you do the deposition. I think we're at a point where it's your burden to do attorney's fees and sanctions, and you can do that, and we're having a hearing on that day. This is, again, look at what he says here. This is going against Vic in why I think that Chupp's not going to grant a continuance. Chupp wants to get this off his desk. I think that is true. I think he wants the path of least resistance. He doesn't want to have a deposition of Slatosh because it's going to confuse things. Extend time. It's going to make it longer. Chupp likes it short. He wants it short. He wants it out. He wants it to go to appeals. He wants to have the appeals court deal with it. He doesn't want to deal with it anymore. This is my operating theory. I have not changed it. This hearing confirms my operating theory to me. That's how theories work. I think Chupp wants this to go away. Go away. Just get out of my courtroom. Stop showing up and talking to me. How much? I mean, you're talking 250. And other ones are probably the same, aren't they? No, Your Honor. Oh, why not? That's a good thing. How much are the other ones? I believe one of the others have attorney's fees, give or take around $60,000. Okay, we're still talking about a lot of money. Yes. And Funimation, I think, is $170. $158 for one, $170 for the other. So we're getting, that's Mr. Martin. That's the counsel for Wick Phillips. We're getting to $500,000 pretty quick. Does this indicate what Chupp's thinking? Don't be surprised if the award amount comes suspiciously close to $500,000 on the money. Sanctions and fees and all that combined. Don't be surprised. Two things. Don't be surprised if Chupp awards them everything they've asked for because it's going to appeals and he knows it. Second, don't be surprised if he just indicated that he was planning on giving them $500K between the three of them. Fees and sanctions, whatever it is, $500K. That's a huge deterrent for a normal person. And that's actually how the statute reads. It's not all of your attorney's fees and whatever sanction. It's reasonable attorney's fees and sanctions sufficient to deter the filing of similar lawsuits or whatever. The court could technically determine that reasonable attorney's fees are zero. Reasonable and sanctions are zero. They can do that. There's case law supporting that. Or at least on attorney's fees, a very nominal amount. Sanctions, they can ghost him if he wants to. I think he's giving us a hint here. $500K. That's the total bill I'm willing to put out against Mr. Mignogna. $500K amongst all of you. If that's the case, don't be surprised if that's his total amount, attorney's fees and sanctions. And then also, I would suggest don't be surprised that he just gives them whatever the hell they ask for. So go see the things. I'm a pessimist on this. I think Chupp wants this out of court.
Plus, we're going to have additional attorney's fees.
Yeah, I understand the necessity of having him testify, but I don't think it's necessary for this hearing. Uh-oh! What do you mean, Chupp? I think it will be necessary in the future hearings, if there is any, to obviously get him to testify. What future hearings, Chupp? What future hearings are you talking about? Certainly, you couldn't think this is coming back on appeal. But I mean, we're just talking about sanctions and attorney's fees, but you already have your attorney's fees. I think the sanctions, you can probably base it on the pleadings pretty easily. So Chupp, you already have your attorney's fees. Again, I think Chupp is prepared to award them what they ask on attorney's fees. I think he's playing dumb on asking how much it is, by the way. I think he knew.
Okay, Judge, we issued trial subpoenas for Mr. Mignogna and Mr. Beard to testify.
Yeah, why do you want Mr. Beard to testify? That's kind of weird.
I think it's the 6th element under Chapter 10 that talks about the attorneys and their involvement in the sanctionable activity. And I may not be able to, if the court ruled against me with regard to Mr. Tosh, I could ask Mr. Beard the same questions.
But you might find Mr. Tosh at DFW Airport one day and you can get him.
After the court has already granted the motion.
You could subpoena him to come here.
He's outside the subpoena power of the court.
Not if he's sitting at DFW Airport, he's not. Tosh is making a very interesting, or not Tosh, Chupp is making a very interesting statement. If you enter the jurisdiction of the court, you can be subpoenaed. Like, you have entered into the jurisdiction, you have availed yourself of the protection of the court, ostensibly, and therefore you can be expected to appear. Tosh needs to not be within 150 miles of the Tarrant County Courthouse from the date of the hearing through tomorrow's hearing, through the next hearing.
Well, that's true. If I could find him there, true, which is why I did the subpoena.
No, I understand. Or Abilene, you'll have to get the ruler out, but Abilene is probably about that.
Your Honor, how about if we have an hour limitation on the deposition? Please, give me the depo. We could do it electronically so that everybody could attend.
My problem with that is I just think it's going to confuse everything to a certain extent, and I don't think it's necessary. And I think that I have to show that I have good cause. So he's still in the statute here. This is important to note. He's not saying Lemoyne has a right to automatically get the deposition. He's saying, I think the stay is in place, but I, as judge, have the ability to grant a deposition under good cause. He's tipping his hand here. He doesn't agree with Lemoyne's argument. I have to have good cause. I don't think there's good cause. I think you have enough. You already told me you could get Mr. Beard or somebody else to testify, so I don't know there's good cause. This is dumb of Chupp, by the way. This is funny. Mr. Beard or somebody else to testify. In just a second, he's going to say, Mr. Beard's not testifying. So you're saying you want a number 6 on...
It's not in the actual statute. You'd have to go through the Lowe decision. I think it's...
Oh, okay.
Henry versus Lowe, Texas Supreme Court, 2007. Cited in the Landry case, which is, if you had our actual motion to compel, it would be page 3. We cite the Landry case in full, and it's G. Ain't nothing but a G thing. If you look on page 4, faux. It is the relative culpability of the client and the counsel and the impact on their privileged relationship. So if Mr. Mignogna wanted to make the argument, I don't know about the evidence. I didn't know about the evidence. I'm just, I'm relying on my attorney. So my guess is that Mr. Mignogna didn't actually talk to Mr. Tosh. It was all done through Mr. Beard.
Cool theory, bro. Cool theory. I wonder if you're right. I bet Mignogna had no part in his discussion about his own contract. Probably not. Anonymous. Uh-oh. Is that you, Anonymous? It says, hello, Mr. Nicholas Hard R. Boomer. Info on signed Vic posters. I've got one of them figured out. I have to mail to Russia. Got to figure out how to get it there, a little bit of trouble. But I will, I will do, I don't know. Should I be announcing I don't know if I should be announcing winners. Maybe, okay. I don't know. I don't know how to do it. Okay.
So the court has to make that determination as well, and the opportunity.
Well, I'll tell you what I'll do. When we have that hearing and you put him on the stand, if I think it becomes relevant to have him come here, I'll let you do it then. So he's going to let him ask Vic about Tosh. There you go.
Okay.
I'll reconsider it anyway.
I appreciate that, Judge.
We'll just see what he says. Is Victor coming? I'm sorry? Is Vic coming to our hearing? Your Honor, at this point, he has been subpoenaed for the hearing. Okay. My expectation is that he's going to be here, Your Honor. Have y'all filed anything on Mr. Beard's subpoena? Not yet, Your Honor. We're within our time limits to do so, but it was just 2 days ago or yesterday, one of those two. We do have some concerns with regard to that, Your Honor. Obviously, yeah, I don't want to have an attorney testify. I mean, I think I don't know how you guys get around attorney-client privilege to have them testify to anything.
What he says to Mr. Tosh is not attorney-client. If Mr. Beard is talking to him on the phone or sending him an affidavit
Is it work product? Does he get into any of that, though?
I don't know how it could be work product. Mr. Tosh is not the agent of Mr. Mignogna. He's an opposing party. If you blast it out on the internet,
if I may, Your Honor, he's not an opposing party. No, he's not an opposing party.
Oh, I'm sorry if I said opposing party. He's not.
That's okay. You're not sorry. You're a catch you next Tuesday.
He's not a joint defendant. He doesn't have a common interest. He's a witness.
And Your Honor, at that point, the concern with that, Your Honor, is at that point, every time an attorney sends an affidavit off to a non-party to be signed for any type of pleading in any type of case, does that suddenly subject that attorney to being called to the stand to testify? This is obviously a problem. This is a problem area. Attorneys should not be testifying in cases. 1, we'll just tell you exactly what we want you to hear. 2, privilege issues. Those are the 2 things. Very, very bad. Very, very bad idea that we should be subpoenaing and having testified all attorneys that sent out an affidavit. They're getting at the fact that he doesn't have any evidence for what he's claiming. To be for any type of pleading in any type of case. Does that suddenly subject the attorney to be called to the stand and testify? That doesn't make any sense. That is a routine part of practice. I would, and assuming it's always a dangerous thing, but I would assume that opposing counsel has sent affidavits to non-parties in the past. Does that mean that opposing counsel thinks he should be called to testify? Court says the term work product applies only to materials prepared, mental impressions developed, or communications made in anticipation of litigation or for trial. Mr. Martinez says that's firmly within materials prepared, man. And communications made. These two things. Materials prepared, the affidavit. Communications made, the communications leading up to the affidavit. Firmly within work product. This is nonsense. I mean, that would be a communication, I think, and I assume when you file a lawsuit, they're kind of contemplating a trial. Not to mention the lawsuit was already filed.
But that is shared with somebody that's not in privy with them.
They mean privity. Privity is a contractual relationship, a contractual legal relationship, typically a vertical relationship. I offer you something, you offer me something. You know what I mean. You know what I mean. I'm the buyer, you're the seller. I'm the agent, you're the whatever. We have an agreement between us to provide services in exchange for giving of rights.
They didn't brief the issue, Judge. They did not put on evidence that there is an attorney work product. It's just an argument that Mr. Martinez came up with right now.
Well, I'm coming up with it too, because I think it's weird that you subpoenaed an attorney. That's kind of funny. This is good job, Chupp.
Well, Judge, there is no doubt that if I ask Mr. Tosh what communications he had with Ty Beard, how is that protectable?
I don't think it is from him.
And if you're cutting off, if the court prevents me from taking Mr. Beard on live, and I can't take Mr. Tosh, then how do I get there? Because
this is actually, to Lemoyne's credit, here's the first good argument he's made the entire hearing. This is a good argument. You told me I can't subpoena Beard, but I can't subpoena Tosh because I'm supposed to rely on my ability to talk to Beard. But I can't talk to Beard. That's not fair. This is a good argument. Chupp's going to ignore that. See, I give credit where credit's due. It's just literally the first time. And again, Your Honor,
because if Mr. Mignogna never talked to Mr. Tosh, somebody procured that affidavit. Somebody got him to sign the affidavit.
But I've already kicked the affidavit out. What does it matter? Or they withdrew the affidavit.
Judge, that goes to whether or not they met their elements. Does not go to the sanctions. If the court knew the affidavit was submitted before, where the witness had told the notary, Ms. Rial and Mr. Toye did not have anything to do with me terminating the contract with Mr. Mignogna.
Who is the notary?
Mr. Beard.
And Your Honor, again, that's, if I may, we're getting back into the weeds here. It goes right back to the issue of everything he's talking about and asking all of the justification that he's making for wanting to take this deposition was known to him prior to the hearing. All of it. He could have asked for an extension of time to take the deposition, citing it as necessary with good cause at any time prior to the hearing, and he didn't. Didn't do it. Lemoyne screwed up on that. He also screwed up by not requesting this immediately when the ruling was issued. If he knew he needed this information, because I would anticipate that he expected to win, he expected to have to put on evidence as it related to his attorney's fees. Because as the court noted, the court could have required at that moment, when it granted the motion, they could have said, okay, put on the evidence for attorney's fees. But he really didn't get the affidavit until Saturday, says the court. By the same token, Your Honor, and as Your Honor told him a few minutes ago, he could have shown up at the hearing and said, I got an affidavit on Saturday. I would like to request a continuance. Court says, no, but y'all withdrew them, so it really didn't matter. Exactly. Oh, look, he just led the horse right to the trough. But what I'm saying is I don't know that he could have done the deposition of Tosh before that, because I don't know that he necessarily knew that was who was going to testify. My point there, Your Honor, is if he believed after receiving the affidavit, and even despite the fact that we withdrew the affidavit, if he believed that Mr. Tosh was now an integral witness as it related to the sanctions, then he should have requested that information from the court prior to the court making its ruling. All right, we'll just have the hearing. Chupp's tired of this. I maintain my position. Chupp is tired of this. And if I feel like we need to do some additional work on it, we still can. What else? Do I need to do your motion for sanctions, or would you rather me just deny it? Mr. Martinez, it sounds like the court is gonna deny it. I mean, I think we needed to talk this out and work it out. I don't know that it's sanctionable, anything that anybody did. So y'all really coming on the 21st or not? Y'all probably, to protect yourself, need to file a motion to quash on the subpoena. For Mr. Beard, I would think so. I mean, I'm not your appellate lawyer, but I think you probably ought to do that just to protect yourself on that. Yeah, of course they do. And he's just indicated, file the motion to quash. Absolutely, Your Honor. Are you coming on the 21st?
We are. We're coming multiple times.
Okay, what's the deal with the appeal, though? I mean, this is another weird spot. This is what I was talking about earlier. Chupp literally doesn't know how this process works. This isn't a slight on Chupp. Judges at the lower court level don't know. He doesn't know if he's made a final ruling or not. And we're going to hear about that now. What's the deal with the appeal, though? I mean, have they kicked it back yet? Because they're going to. I assume he means they're going to deny the appeal because it's still ongoing, because he still has jurisdiction. Mr. Martinez says, that's the deal at this point, Your Honor, is that we did receive... What? What's up, lady? Okay, I'll be right back, guys. Sorry. Okay, I'm back. My apologies again. Oh my goodness, we got little young kids waking up in the middle of the night and me not wanting to clean up a bunch of urine. Go figure. All right, here we go. Back at it. Back at it we go. Okay, so is the Court of Appeals kicking it back? We did receive a notice from the Court of Appeals that they wanted some fees paid and things of that nature. Yes, the fees got paid on the 14th, by the way, just so everybody's clear on that. We have until the 14th to determine that. And in reality, Your Honor, I guess what we're trying to do to be sure of was that we didn't miss a window. The court, I understand that. Of course they do. And this is where Lemoyne shows himself to be a true scumbag coming up. Martinez says, from that perspective, right. If the court says on the record that this is not a final order as of this point, and then after the 21st, when the court renders its ruling at that point, that would be the time for us to issue an appeal, we are happy to withdraw our appeal. Now notice, withdraw our appeal. Notice what Chupp doesn't do, though. Because Chupp could do this. They could get it on the record. Chupp could do it. He doesn't do it, which is a dick move by Chupp. Because the filing fee for the appeal is pretty high. It's pretty high. Court says, yeah, I think that is my understanding, is that is not a final order at this time until I've issued the final order with regards to the sanctions and attorney's fees. So, I guess we can go ahead and have the hearing. I just don't want them to get mad at me for doing something when they think they have jurisdiction over it. Mr. Martinez says, and Your Honor, that's why I say, as long as we have an understanding or something on the record where the court says this is not a final appealable order, but that should, back on that, I apologize, I think I reserved in the order that we would have a hearing, I reserved jurisdiction over it. Martinez says, yes, sir. The concern, Your Honor, with it was the wording within the order itself at the very beginning, where it states that the court finds that the 3 motions should be and are granted in full. So that causes concern that there could be at least an ambiguity whether the court wanted to bifurcate and or what. So if the court is telling us that the court does not believe this to be a final and appealable order that was granted and issued by the court on October 4th, then we will withdraw our appeal pending the final order of the court after the November 21st hearing. So they're saying, look, if you said it was granted in full, as in a final order, it's done. But if you say now it's not done, just say it and we'll withdraw, and then we'll refile the appeal when it is done. Okay? Please just do that, Chupp. Let's just get it on the record that it's not done, and then we can file when it is done. Lemoyne says,
we filed a motion to dismiss the appeal. You granted our motion in full. Our motion in full says dismiss claims and that set a hearing for sanctions and attorney's fees, which is what the court did. You can't read the top part of the order without reading the last paragraph that says we are going to have a hearing, submit in 30 days. But if they want to dismiss their appeal, it's fine with me. If the Court of Appeals wants to stop this court from doing anything, they'll let us know pretty quick.
Here comes the scumbag part. They usually do. I can redo the order and just say, Martinez says, I don't know if that's necessarily a need for that, Your Honor. Like I say, as long as the court, and we've got a record today, as long as the court is telling us that this is not a final appealable order that was issued back in October, we will withdraw our appeal and refile the appeal pursuant to the court's forthcoming order after the November 21st hearing. Court says, I'm telling you this is not I did not consider this to be a final order. He equivocated. I still would let the appellate court know this before you dismiss it to make sure they understand that, because I don't want them to think the clock is ticking. Chupp doesn't even know if he issued a final order or not. The TCPA is a garbage law. Martinez says, okay. And so, because I don't want you to get in a position where they think it was final because it says dismissed in full, so I would like for the appellate court to just send me something saying it wasn't. Okay, then we will go ahead and pay the fees, Your Honor, and move forward with the appeal as set, and the appellate court can make their determination. Lemoyne says,
and Judge, we would be stopped from making the counter argument, from taking the position both in the letter to you and the motion that's set before the Court of Appeals, that we don't think it's a final judgment.
Chupp says, but the problem, I think, is that we are 30 days past this now. And so if for some reason the appellate court thinks it was a final order, you'll get 0 on attorney's fees and their case goes away. But they may like that too. I don't know, because you'd get 0 and everybody walks away. And so that's not a bad deal for them either, to a certain extent. And so I would just have concerns without getting something from the appellate court saying that we need to hear it, that it needs to come back here. I think it could hurt both of y'all, to a certain extent. So, because if he withdraws the appeal and they say, well, that wasn't, the 30-day clock was ticking and you missed it, regardless of what I say, they don't care what I say. Aw. Aw, Chupp. Here's the disgusting scumbag sign of Lemoyne. This is him showing his hand on exactly what he intended to do.
Well, if he withdraws the appeal, there is no clock on the attorney's fees. Multiple courts have ruled that the motion to dismiss itself and the ruling on that is what triggers your 30-day clock.
Wait a minute. Lemoyne is right there presenting the opposite argument. And he's flat out stating that he's trying to extend the fees beyond the 30-day window. What a dickbag. Look at this.
Once the hearing is heard, you've got 30 days.
Oh, wait, no. He's saying this as far as Chupp's 30-day clock, but he's going to say what I said in just a second. Here it comes.
If you do not rule the court, the cases that have been interrupted after that, because the litigants have tried to do kind of what you've described. Just we're going to run out and appeal the grant of a dismissal to try and kill the attorney's fees. Every court of appeals in the state of Texas has addressed that issue, has said that sanctions and attorney's fees do not have a clock on them. And that's but
it would be an unfair situation if they missed their appellate deadline and you still got to get your attorney's fees.
It couldn't happen.
Okay.
How could it happen? They would still have a right to challenge, at a minimum, the attorney's fees.
He's saying they'd have a right to challenge the attorney's fees, but not the underlying ruling. But they should be able to challenge the whole thing. That's my only concern. And I haven't read every TCPA case, so I don't know. But I just don't want you to be in a position where you do lose your appellate right, and you still have to pay attorney's fees too. Martinez said, well, and I'll be honest, Your Honor, I have to complete my briefings on the case, but if what opposing counsel is saying is correct, which is once the court issues its ruling as it relates to the motion, it starts your clock, regardless of the fees, that means that your order was ripe for appeal. And
No, that's not what I said.
I know. See, I know it's a little confusing, though, I think. So do whatever you think is right, and I'll see y'all on the 21st. And if you want to take this transcript to the Court of Appeals and say, this is what the judge said, are y'all okay that he still has jurisdiction? If they'll issue that, then I'll be fine too. And this is how it should happen, not in the way that Chupp is describing. How it should happen is the two parties should agree to just send a note to the Court of Appeals saying, we acknowledge that this was filed, it was timely, but it's not ripe, and we'll just acknowledge that when it is ripe, under the rules of Texas appellate court procedure, when it is ripe, we'll address it at that time. Can you please stay it until we have a final order on this thing from the court? That's how it should work. But these two parties are beyond the ability to work together. Your Honor, if I may.
Yeah.
Yes. For point of clarification, can I confirm that I denied this is Martin. I denied their motion for sanctions. Thank you, Your Honor. Yes, y'all are on. Is it Thursday or Friday? Thursday the 21st. Okay. And for the same sake, Your Honor, just to be absolutely sure, there's a denial of their motion to compel. Yes. And sanctions associated with it. I denied their motion to compel, but if they want to re-urge it at the hearing, I may still let them depose that guy if for some reason it comes up. I think you're probably going to need to prepare to find a better way to get the testimony you want other than from a lawyer that's sitting there, because I'm probably not going to let you do that.
I understand, Judge.
Okay, I guess if you send me orders, I'll sign them, or basically denying the motion to compel and denying the sanctions is what I've ruled on.
Okay, thank you.
Thank you, Your Honor. Thank you, Judge. Oh, thank you. I would have left you there all day. I forgot you were there. Y'all have a good day. And Sam Johnson, I think he's gone. He vanished into the ether. That's the end of this. That's the end of this transcript. Transcript
from a con slut.
Let me let me get this pulled up just a moment. I said I would go through Al-Anon's hard work and Al-Anon and read his hashtag. So we're going to do that real quick. Should just take a minute. All right. Here we go. So we just got the hashtags at the bottom of each page. So the story on these is T. Greg Doucette writes stupid hashtags. Al-Anon, after removing his watermark, writes funnier hashtags. So these are from Al-Anon on Kiwi Farms, I believe. I believe it's him. If not, I apologize. Hashtag bye bye bankruptcy. Hashtag broke ever after. Next is hashtag bald Shane. Oh, that's rude. Hashtag Disney World bar exam. Oof. Hashtag clients. What clients? Hashtag no case, no losses. No cases, no losses. Oh no. Hashtag sinking sped knot. Blockchain bravery. Next we've got just grifter things and hashtag 3 months behind. This is a reference to, of course, T. Greg's bankruptcy dismissal that is pending. He has until tomorrow to issue his response, I believe. I believe is how that goes. I'll be very curious to see if it's issued. Maybe you should just write a check. Better than super chats, saving Nick money, sweating the appeal, spinning forever. Here we've got tweeting in private, blockchain lawyer. Oh man, poor Lemoyne. Desperate to be clever and dreaming of lemons. Damn it, Shane. Not Kiwi Farms again. We have wheezing lawyers and repossessed CPAP. The stories that CPAP could tell. Hashtag sometimes I lay awake in my cardboard box at night and think to myself, hashtag why don't people like me? Everybody likes Nick, and he's not even funny. He's just a drunk lawyer. I'm a funny lawyer, though. I crack a lot of great jokes on my podcast and on my Twitter all the time, but nobody voted for me. Someone voted for Legal Eagle, but not for me on my election bid. WTF, why? Why can't I be like Nick? Aw. I'll get drunk too if I have to. I'll even joke about the son I abandoned. I just want to be loved. This is a sad hashtag story. Get a hold of yourself, Greggy. You can do this. You got 30,000 followers. Just keep buying transcripts. If I keep watermarking and hashtagging things, people will like me. I'll be famous soon. Straight out of bankruptcy. Sue me, daddy. Chapter 11 cruise ship. Always be grifting. No hair, no sun, no worries. Oh my God. Judgment proof life. Hashtag not a Kiwi. Hashtag only one mass shooter. Oh goodness. Hashtag too cool to be sued. Hashtag except by creditors. Outdone by a 4th year bald-faced lawyer. Oh, these are mean. Hunting for con sluts. Diversity dating. Gasping for relevance. Sexy CPAP. Casting couch blues. Star markers. Star Maker Sabbath. Oh, God, come on. Subpoena Envy. Notice me, Lemoyne. New wife, new grift. Shared debt for life. Oh, that's rude. Lol Twitter. How exceptional. Defaming daily and just bankruptcy stuff. We've got empty autograph lines. Hashtag say conspiracy. By the way, you know who doesn't have empty autograph lines? Vic. Vic doesn't have empty autograph lines at all. They're still full. They're still full after 10 months of this. After a bad result from the hearing, his lines are still full. It's a mess. It's a mess for them. Hashtag toilet tweeting. Hashtag no time to work. Hashtag predicting lawsuits is elementary, my dear. What? What, son? Oh, that's brutal. Oh, goodness. That's That's the premium joke right there. That's a pun. It's a meme. It's a burn. It's true. Everything about that is brutal. That was dang. Hashtag missing Nick. Hashtag lonely Twitter thread. Hashtag no GFM November. Hashtag chapter 7 incoming. Hashtag 13 reasons why I grift. Hashtag number 1, I'm broke. Son said, see you later, Dad. I always see him first. About to fail, no GoFundMe November. 0 clients in 2019. This is important. I have information that could lead. Wait, what's that buzzing sound? No, T. Greg, don't do it. Don't do it. Don't get a bunk bed. Oh, no. All right. There we go. That is the documents. What happens to the GoFundMe money now? Square one. The GoFundMe money is still paying for Vic's counsel. That's what happens. Oh, I suppose I should bring it up here. We'll check both GoFundMes. We'll check Vic's first. Here we've got where did that go? There it is. We're at $261,836. We've got Dominic Lusso, thank you. Ron Toye Beats Women, Tom Young, and Anonymous. Thank you guys for your very generous and kind donations. And then checking up on Mr. W, Mr. Heath's classroom library. We've got 5,688. We doubled, more than doubled what he came into the show with. You guys have made a massive, massive impact in the lives of these kids. You really have. I don't know that he has seen all of it. He messaged me 2 hours ago, and that was before it got to the 5,600. He was speechless. I'll let him at some point come express his gratitude. You guys have been phenomenal. Thank you so much for supporting me and supporting him, and most importantly, supporting those kids in that. Last ones, we've got DJ Wilson, Office for Men, Jordan Rankin, Anonymous, and then back to Angron, who we read earlier. Thank you guys so much for your donations. I really do appreciate it. It means the world to Heath, and it means the world to those kids. Really does. So hopefully he will post a final update with the next order of books that comes in. You can check out all of the updates. He has done 5 of them, showing the book boxes that have come in, showing the books and stuff like that. You can see he's got accountability on what's actually coming in there, and you can see how he's changing stuff. And I hope he will do a final update before he does close it down. I know he's talking about, it's been open a long time. I know he's talking about closing it down. So, but yeah, so there's that. All right, we've got Random Blaze says, let's not forget that Jamie Markey has a charity kicking into her lawyer's fees now too. That should be brought up in the fees and sanctions hearings too. I agree. Will they do it? I don't know. But I'm sure they're on top of all that. So, and yes, I did get matched for that $200 on the library GoFundMe. All right, what I'm going to do is I'm going to read through Justice Chats and then Super Chats. I've been doing Supers then Justice, but we're going to do Justice and Super Chats today. And then we're going to wrap up the show. I think it's been a great show. I hope you guys enjoyed it. Lots of stuff going on in this. I will report to you on that hearing as soon as I know what happens. I expect, like I said, I'm pessimist. I think Chupp is going to award them either everything they asked for, or just because he indicated it, some total right around that 500K mark. However he gets there, I don't know. I don't know that he's going to issue that ruling tomorrow. I think he's going to take it under advisement for 30 more days. I really do. But, it'll depend. They're going to apparently call Vic to the stand and have him testify. So, I don't know if that went as well as they wanted it to at deposition, but that's what they're going to do. So I don't know how it's going to go, but hopefully I will be able to report on it tomorrow, at least impressions, if not rulings. I obviously will not be in Texas tomorrow as much as I would like to. It's just too close to the holiday for me, and I cannot get away right now. Plus, I teach tomorrow, so that would be another. I can't miss another teaching session. I missed 2 right at the start of the semester, and I can't do any more. So, yeah, that's that. Let's read through these things, and then yes, I will be on Twitch tonight. I think for a little bit. I don't know that I'm going to play an RPG because I'm mildly hammered, and I don't know how much longer I can stay up. I'm really dragging on the fatigue front. I kind of might want to just play like something that's not so long. But I don't know. Maybe I'll either play Risk of Rain 2 or Pathfinder. One of those two. Even though I think I may have picked the worst class in Pathfinder. We'll find out. Yeah, I teach at our homeschool co-op. I teach high schoolers about the Constitution. So, to answer your question on I teach. Yes. Yes. All right, let's do it. The Pie Baker says, who wants to bet those redactions on Lewiney's bill is from his assistant super chatting about her boss wanting to give her West Nile AIDS? Gross. Napao Giandi says, say in Lemon Man's voice, I need my consulates. My consulates. The Pie Baker says, how much cucks could Judge Cuck judge if Judge Cuck could cuck judge? That's actually really hard to say. Kusaruki says, the money I gave you last time got somehow refunded. Just take my money already. I beg you. Oh, thank you. I will do that. Hated 7 Days to Die says, long time no see. Hey, yeah, you too, buddy. Welcome back. Anonymous says, very Hirosho Tavarish. I don't know what that means. And yes, I will wear a thought top on Twitch. Don't at me. Agrilith says, I think you played EQ EverQuest since we are about the same age. Favorite race / class. My favorite race was Gnome. My favorite class was Bard. I played a human Bard because you couldn't play a Gnome Bard. But yeah. Gnomes always looked like they were running faster than other races when you were playing them. It was great. Hichigo Shirosaki 276 says, every content creator on YouTube is in serious trouble, and this issue needs more attention. Look up COPA and FTC for details, or maybe do a show on it. Yes, we do have shows coming on those. Rolf Alexander says, more freebies. Hey, thank you. Lina Kalen says, Lina Kalen says, time to dump the free super chats. Hey, thank you. Robert H says, free super chat. Duck. John is playing Breath of the Wild, says, free from the U of the tube. So here, have the 50 cents you'll receive. Oh, thank you. Brian P says, free super chat. Lina Kalen says, GYM and Rekieta time. Hell yeah. Also says, time to have some boomer sips. Ooh. Franco Miranda says, super chat for you. Thank you for your hard work and continuing coverage of the Vic lawsuit. Hey, it's my pleasure. Thank you. Rick Nikita says, wah, cry more about your disrupted sleep schedule. Fight me IRL. My dad could beat up your dad. Oh, let me say it. I was supposed to say it in the middle of the show. I'm so dumb and stupid. The Discord. Come check out the Discord. Joining on New Project 2 or Patreon get you access to the Discord. $5 a month, get you access. Great Discord, great community. It's curated in the sense that there is not a million people in there. It's only other members of the Patreon and New Project 2 community in there, so you can actually have conversations. You can build relationships with people. You know there's going to be some consistent timings where people are going to be around who you want to talk to and all that stuff. I pop in there every Wednesday for a live chat and random evenings for other stuff as well, just as I have time. There is a new $20 reward being rolled out soon. I just have to figure out exactly how to best implement it. It will be story time with Nikki Rackets, where we will read together all sorts of great books and stories and stuff like that. So not legal related necessarily, although maybe sometimes, but we will be reading books together and just kind of hanging out and having a story time, like an audio book but live or whatever. So come check that out. Come check it out. Also, I've got a new Cooking with Racket stream coming soon. Chandler West says saving an Oban 14 bottle for end of the semester. Ooh, good choice. Good choice. I love the short videos. Keep up the great work from Sean Clark. Sean Clark. Wait. What are you saying? Holy crap! I gotta pull this up, guys. The chat donated an additional $2,000. I don't know who the chat is specifically, but whoever you are, thank you. Thank you so much. That is amazing. That brings a total to $7,688. That is phenomenal. Thank you all so much for your support. That is amazing. Huge donation. And again, I can't express my gratitude enough. And when Heath, he's teaching in the morning tomorrow. I teach late morning. He teaches a normal teacher's hours, so he's got to be up early. He's asleep right now. I'm guessing he has no idea. This is gonna blow his mind. The chat always wins. Absolutely, the chat does always win. The chat is ultimately the dictator of all of this. So, what else do we do this for but the chat? So thank you guys. That is, I don't even know what to say. Sean Clark says, I love the short videos. Keep up the great work. Don't worry. More short videos are coming. I am still working on the Syracuse University situation that you guys probably don't even know is going on. But it's crazy. I'm getting reports from inside the university, and I want to bring them to you. I'm hoping to get some pictures or something that I can share of the situation. I've got videos and words from the faculty, from the chancellor of the university, from the head of public safety and all of that stuff. These people are idiots, and they're dealing with communists thinking that they're dealing with rational people. And I can't wait to tell you about it. I can't wait. What situation exactly? Syracuse University is losing its mind right now, in the full flavor of perfect millennialism. Do we have another problem? Okay, guys, I gotta be right back. Sorry. Yeah. Oh my goodness. I apologize again. Sorry, I apparently have like a kid who's getting sick. So that's fun. All right. Back to where we were. Franco Miranda says, if you plan to go to Cali, go to San Jose. I've been to San Jose. They have an anime convention in May called FanimeCon. Their motto is by fans for fans. Just saying. Ooh. I wonder if FanimeCon would like to talk about that. Dave A says, take my free super chat money. Keep on keeping on. Thank you, buddy. Kalinka Pavlova says, I'm still hurt you didn't tell Heath about the book burning wench and potential free books. But yes, donate, guys, please, even if you thought he was a boomer. And then Juro says, I have 4 free super chats. I don't watch anyone else live, so I want to give them to you throughout tonight's stream. Hey, thank you. TrueSid2 says, don't read this. Free YouTube check currency. Thank you. Some nobody says, uh-oh, did you lie to the judge? How unfortunate. John Cook says, Racket, have you looked at this COPA thing yet? Working on it. TLJ Screwjob says, Monica isn't an agent of Funimation. That's why we pay for her. Ethan Amante, thank you. Nix Hex says, Nikki, do you think Mr. W will appreciate me sending him a copy of Men Are Greater Than Women instead of a donation? Yeah, go ahead and do that. That'd be great. I'm sure he'd get a kick out of it. George Georg, thank you for the donation. The Scott16 says, hi, Nick. Been a while since I was able to super chat. Did you get my email about YouTube fine print for super chats? Be interested to hear your opinion on the possible legal ramifications there. I have not read that email. Let me double check and see if I've gotten it, and I will respond to you. Brian Duick says, by the way, Nick, your channel is targeted at kids due to bright colors in the thumbnail. My channel is not recommended for children. I put that on there that the content of my videos, of every video, is not child friendly. Kirito de la Garza says, hey you. Hey you. Addie White, thank you. Some nobody says, one day T. Greg's kids will have sleep apnea too. Aw. Phantom RA Cast says, Fireball is the best whiskey, changed my mind. Yeah, it's really easy. Drink it. Some nobody says, you can learn everything you need to know about Lemoyne from getting stuck head first in a horse's money. Cowboy horse. Juro says, your Lemoyne voice gives me life. Latintha says, F in chat for Yellow Flash 2 hitting 100k subs. We covered that earlier. Congrats to Flash. That's amazing. And he followed up with a shot on me. Enter the Cube. He says, can the defendants appeal the appeal? They could go to the Supreme Court. Sure. Mario Carter 13 says, shouldn't have stuck it inside the Reaper consulate. Some nobody says, admire Lemoyne trying to school marm R3T ARD though. The Crow 751 says, narcolepsy with cataplexy sucks. Free chat. I don't get cataplexy too often. I don't get it in the cataplexy is where you have like your body suddenly floods with the sleep paralysis hormone and you get extremely weak and often will fall over. That sort of thing. I don't get it while I'm doing stuff. Where I get cataplexy is if I'm sitting in a chair and I get to the point where I'm about to sleep, or if I lay down, it will be like, and it doesn't take long. This is pretty quick. It will take work to get my ability to get up and move. It's crazy. The Crow 751 says, $5 handies for how long? One hand or two? Look, buddy, we'll hand job both of those hands, but it's $10 for two. Cloudfire 181 says, thanks, Nick. I really need this night after things going wrong today. Also, what happens to Ron and Monica when it's shown they lied in court? It's up to the court. We'll see. Luminaire says, why doesn't Vic object to Lemon lying to the court? I assume they'll get to it. It's up to them. Who knows? Objections on the fly in court aren't super easy, especially when it's a hyper detailed sort of thing. Something you tend to come up with later in a written motion, because you don't usually have the transcript right in front of you at the hearing. God of Twilight says, yo man, been a while. I've been busy, but glad you're still going strong. Get whatever you can do with this. Thanks. Super Saiyan Serg says, yo, Nick, you're a bro for helping Vic. Hey, buddy. Thank you. Super Saiyan Serg says, yo, Nick, can you tell Ty? Thanks for helping Vic. I will. Steven Steele says, free chat, enjoy. Fenrir Fire says, Indiana Chupp and the Raiders of the Lost Fart. Super Saiyan Zerg says, yo, Nick, you're a bro for helping Vic. Hey, thanks again. Some Nobody says, guys, Chupping Private Ryan. Joel Donadio says, my favorite comedian is Dave Chappelle. Fusion of Tarot says, I've been meaning to support your channel and also to help Vic and Todd where I can. I know it's not much, but thank you for being awesome. It is much. It is the world to me. Thank you. Your support means... I don't say this lightly. The ability to do this as a profession, as a job, to hopefully entertain and educate and share news with you guys is it's supported by you, and it's amazing for me. I get to be at home with my kids. I get to do this and hopefully bring some light into your YouTube viewing. That I can't ask for anything more. The Wrong Crafter says, hey, Nick, I'd like to ask if you're going to do a video stream about the COPA law and YouTube case explaining it because it looks bad for YouTubers. Yes, we're working on it. GRP poll says, have some money for being the only stream I've passed out listening to. Wish me luck with the medics. Good luck, buddy. Good luck. Bowsette says, shake your chup more than twice. You're playing with it. Mario Carter 13 says, JF going down on the con sluts like the syndrome. James Panzone says, it's hard to ask this. It's from the heart. I love you, your skin. It all ends in a pedestal of your beauty. Will you cushion my tushin, Chaircoon? Juro, thank you for the donation. And then finally, anyways, here's a total of $20 of YouTube's money. Do what you want with it. And have yourself a good night. Hey, thank you, Juro. I really do appreciate it. Thank you. Prof West says, I bet $5 that one of the Ragged Links fell out of bed and was crying. Shout out to Joey Rodriguez III. Actually, no. My 4-year-old just wakes up and something about when she's asleep, she doesn't think to get up to go to the bathroom. She'll just cry. And so it's like race to get her in there, get her to the bathroom, and then she'll go. She just is not good at actually waking up. She may, in fact, have some sort of narcolepsy too that makes it hard for her to actually kind of wake up out of that sleep. And he says, shout out to Joey Rodriguez III. Kolfi 2A wannabe Haunan Muhammad says, when life gives you urine, make urinade. Gross. Felix 1942 says, F this, I just want to clock out the court. Senpai's Home says, the grift is real, Nikki. The grift is always real. Tetsuo Wrath says, for bacon, cheap booze, or throat lozenges after all that Lemonese. Thank you. Brian Dewig says, get it right, Nick. Druids and shaman run faster than everyone. Gawker's Death Rattle says, new Project 2 issues now been sorted. May join tonight. Yes. New Project 2 is fully operational. There's actually just a very short window of a hiccup, and Dick had a backup processor that took over, and things are going right now. So they're working. F says pizza on pineapples. There you go. Karite Sumitai says, oh wait, I read that one. The Crow 751 says, crack open a bottle of Kraken. I've never had Kraken rum. I've got to try it now. Bad Vibe says, I almost wish this case was a dramatic comedy. This would be funnier as fiction. I agree. Jason of the Great Awakening says, my favorite in chat so far is Schindler's Chupp. Eggs Benedict says, for more Chaircoon streams. Kalinka Pavlova says, someone donated 2K to Heath? They did. Isn't that amazing? Twisted Puppet says, can you cover the guy who sued his New York City employer claiming he was fired for his sexual orientation? I'm not familiar with that case, but if you email it to me, I can maybe look at it and see. F says, in the same way you say you couldn't do this without us, we also wouldn't have this without your continued effort. Hey, thank you. Crow 751 says, which is worse to you, cataplexy or sleep paralysis? It's probably it's whatever I described. I don't get the cataplexy where I just fall over like that. That just doesn't happen to me. I can do the physical activities and stuff like that. I can go upstairs. I can I can go for a run and stuff like that without having a cataplexy episode. So I guess it's the sleep paralysis. That's the toughest part. Mainly because if it's in the middle of the night and I have a kid who has an issue and I have to get up, it's really difficult to do so. But on the plus side, it's really easy to get back to sleep. And Isabel Caden says, "Hi, Nick. Good stream. Love you. K. Bye." Hey, thank you, Isabel. Thank you for that. I really appreciate it. And that, I think, is the end of the show. We're done, guys. Thank you all for hanging out. Please do. There may be a link to a poll or something. I don't know if it's in a card at the end or maybe it's in the corner. I don't know. I can't see what you guys see anymore. This is a little different how YouTube has it set up now. There is a poll. Check it out. If there's not a poll, don't check it out. Oh, we got to get some outro music, which we haven't had in a while. Oh, there we go. There's that outro music. Fluffy Side Up says, the West Virginia foster care system and FPS are being sued for neglect and other things. I think it'd be interesting to hear you talk about it since you were a foster parent is how I think you wanted to end that. Yeah. I hate family services. I hate them. I don't like anything about the government being involved with the kids. But I'll take a look at it. I think the same thing is happening up here in Minnesota. Actually, there's some issues with family services. I'm not sure exactly what the issues are, but they might be related. Who knows? I'll look into it. I know a guy who works as a county social worker in Texas, and might be interesting to have on the stream. I think he would have some insight. You know, obviously not to West Virginia's situation, but just in general as to what these guys face in the system that they work in. Because when you find people who get out of that system as employees, not just as foster kids, they and you can get them to open up, the stuff that they have to go through is soul crushing and awful. And a lot of it has to do with how the government handles those situations. So that said, guys, thank you so much for watching. Make sure you come over and check out on Twitch if you're still awake. If you're awake and looking for something to do, come hang out on Twitch. If you have more questions and you don't want to super chat, come do it on Twitch. It's easier for me to answer there to a non-super chat. I will see you guys. We should have a show tomorrow. I'm not sure what the topic's going to be. Oh, it's probably going to have to do with the hearing, but we'll see. I don't know if that will fill the show tomorrow, but we've got plenty of stuff to cover. Come hang out tomorrow night. I will see you then. Have a good night. Peace. Peace.
Get unemployed, so pour out a glass for the team. Post on Twitter as we hear lost blaming tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. From the white shores of Nan to the hills of
Oh, you guys are Bye.